to the point. We must stick to the timings in the programme motion. The committee has already agreed, and for this section we have until 10:05 a.m. So could the witnesses please briefly introduce yourselves for the record, and if you are to give an opening statement, please keep it short. Thank you very much. Sir Chris Whitty.
Thank you, Chair. I'm Chris Whitty. I'm the Chief Medical Officer for England, also representing the Chief Medical Officer for Wales. One statement, which is on behalf of both Duncan and myself and all the CMOs, is we are completely neutral on the principles of this bill, which we consider are entirely for society and therefore for Parliament. So although we're answering technical questions, we will not be answering questions of principle because we feel that is a societal question. We have made clear to the medical profession, however, that individual doctors should be able to make whatever statements they wish, and obviously doctors have strong views on all sides of this argument, as members of society do.
Good morning, I'm Duncan, Barton. I'm the Chief Nursing Officer for England, and also just for transparency, I'll just say that I am also a volunteer trustee of a hospice.
Thank you very much indeed. Those who want to ask questions, please indicate. Nasha?
Thank you very much, Chair. Thank you very much for that. So, Chris, if I could ask you if I can draw your attention to clause 42.3, especially the part which states, but if any provision of this Act has not been fully brought into force by the end of a period of 2 years, beginning the day on which this Act is passed, that provision, so far as not already in force, comes into force at the end of that period. The question is, do you believe that it would be safe to implement this legislation if those provisions have not been fully put in place?
Well, I think that the key thing, if this bill is passed, and I want to stress, and I'm going to say that once, but assume that for all the answers I subsequently give, if this bill is passed, what we will clearly need is both a period of time to make sure that there is technical, both guidance and legislation, via secondary legislation, because obviously the primary will be through the bill, but also necessary training for people to be able to do this in an appropriate and dignified way, if that is what Parliament chooses.
So would it be safe?
Well, I think that what we would want to do is to have the time to do that, but you can do things at speed if you need to. My view is this is something which is best not done at speed if we can avoid it.
Right, thank you.
Avoid it.
Right, thank you. I'm former NHS Commissioner, Sir Chris, and in Bradford West we have high, stark health inequalities. Dr Jamila Hussain, as part of John Wright's team, will be providing evidence this week, and she's found huge mistrust amongst marginalised ethnic groups, and even more so since COVID. And we know that COVID brought to light the inequalities in healthcare access that already existed, especially for economically disadvantaged communities. What lessons do we need to learn from COVID and its disproportionate impact on ethnic minority communities when it comes to this bill in particular and its implementation?
I think that's an absolutely critical question, because it is very important that if the bill is passed, that all parts of society, of whatever ethnicity, of whatever background, have equal access to the bill or not, as Parliament has determined, and that is going to require adjustment in a variety of ways. Some of them can be done at a macro level, for example, making sure that everything is translated into the major languages spoken in the United Kingdom, but a lot of it will be to do with the individual interactions that doctors, nurses and other healthcare providers have with individual patients that must take into account their own starting point, their own knowledge and, of course, most importantly, their own beliefs.
Thank you.
Thank you. So, Chris, you mentioned there about having time to ensure that people were appropriately trained, and the Act as it's drafted includes provisions in Secretary of State to make orders around required training. Could you say a little bit more about that if Parliament did decide to pass an Act of this nature, what training requirements do you think would be helpful and required? And I think I'm thinking in particular around skills around capacity, the assessment of capacity and coercion.
Thank you. So I'll give a view, and it might be useful to get Duncan's view also on the nursing side, because nurses very often will be involved heavily in these discussions. So I think I would divide the kind of training that is needed into two broad groups. Training which is essentially normal medical practice but may need some variation, and things which are clearly specific to this bill. So issues, for example, around mental capacity, as determined by the Mental Capacity Act, is something which is done every day in every hospital up and down the country. Every doctor, every nurse above a certain level of seniority should be able to do that normally. It may require some slight adjustment around this. There's an absolute expectation within the Act, for example, that the more serious the decision, the greater the level of capacity that someone needs to have. And that is already built into the principles of the Act and the way that things are done. So those forms of training, and I would also extend that to, for example, the management of end of life, which should be a normal part of medical practice and nursing practice. We will all die eventually, and it's important. That has always been part of medicine and always should be. That should be generic, but may need some adaptation. Then there will be some specific things which will be necessary for people to understand this Act and to, in some cases, take part if this Act is passed in the final part of prescribing drugs to patients. Now, I think it is much more likely that a very large number of doctors and nurses may get involved in the very earliest stages, because someone may raise an issue with their GP, with their nurse, with their consultant, and they need to have the basic understanding for that. When it comes to the more detailed later stages, that, in my view, will require some specific training. And I think quite a lot of there will be a gradation, in my view, of doctors, ones who are happy to have the general initial conversation, ones who are happy to have the structured conversation that follows, and a minority of those who will be happy to go on to take part in the final stages. It is very important that both the wishes of the patient are respected, and that is the central point of this. We must start with someone in their last 6 months of life and their immediate family, what's good for them, but we must also make sure that the wishes of healthcare professionals around this area are absolutely protected, both from conscience and indeed through choice. Duncan.
Yeah, I mean, I would add to that just to say that, you know, I'm mindful that there are almost two groups of staff here, staff that would potentially be working in this service if this Act is passed. But also the wider workforce. So at 2 o'clock in the morning, when a patient wants to have a conversation with somebody about end of life, it's going to be a nurse that's going to be with them, or it's going to be a nurse in a care home, or it will be, you know, a specialist nurse providing cancer care. So we have to think about the training and support that's required to them, be that around signposting or explaining where they can go to access more information. So there's an important part about the entire wider workforce we need to think about. And then clearly for those people that are working in such a service, thinking about the safeguarding elements of this and how we make sure that the support around safeguarding training, confidentiality, particularly mindful that some patients may choose not to tell their families about this, and how do we enable and support staff in managing those kind of circumstances and navigating the legal requirements through this bill. And then obviously thinking ahead around what we would need to do in terms of undergraduate training, both for doctors, nurses, and thinking about the curriculum.
So if I may, just one follow-up on that. So at the moment, clearly, I'm aware that there are instances across the NHS every day where people make decisions around refusing treatment that would be required to perform their lives. And I think doctors, nurses, and the healthcare team would be involved in assessing capacity and indeed coercion around those. Can you say a little bit about any learning from that, and I suppose the levels of skills required in the current practice around refusing life-saving treatment, and how that might be taken into assessment under this Act?
You're absolutely right that it's a completely normal part of medical and wider nursing and other practice, but particularly medical practice, to consider issues of consent and issues of capacity. And it can be where someone says they don't want treatment, and that could be a treatment which is clearly going to be life-saving. A very well-known example is the example of people who are Jehovah's Witnesses who choose not to have blood products. And if they're bleeding heavily, that is an issue which could lead to the end of their life. And provided they understand that and they have capacity, that has to be respected. The alternative way, and the other thing which doctors have to do, is give people advice before they have made, for example, major operations or chemotherapy or other drugs, which may itself lead to the end of their life, but also may lead to a benefit. So explaining to people the risks and benefits, including the fact that they may lose their life as a result of the next stage. And if someone's at high anaesthetic risk, that is not a trivial risk sometimes with operations. That is a very standard part of medical practice that you do essentially from the point you qualify. Obviously, as people get more senior, they tend to be more experienced in it. And as with most things, if you get more experience, you generally get better at it.
Sarah Olney.
Thank you, Chair. Professor Whitty, I just wondered, the definition of terminal illness is attracting some attention, and some people are saying that it's difficult to define a terminal illness. I wonder if you think it would improve the bill if we could have instead a specified list of illnesses that would apply under this Act. Do you think it's possible to come up with a list of illnesses that are terminal that would qualify under this Act?
I think it's, if I'm honest, I think it would be extremely difficult, and if I may, I'll explain why, because I think it's a really important question. Let's take cancer. For the great majority of people with the majority of cancers that are diagnosed tomorrow, the doctor who's seeing them will say, in all confidence, you have cancer and I expect you to be alive not just next Christmas, but for many years to come. So the fact they have cancer is not in itself a demonstration that they're going to die, and in fact, the majority will not. Almost 80% of people with breast cancer diagnosed tomorrow will still be alive 10 years later, for example. Equally, there are people who may not have a single disease that is going to lead to the path to death, but they have multiple diseases that are interacting in the same person. They're highly frail, and it's not the fact of one disease that's the cause, but the fact of this constellation that is clearly leading them on a path inexorably to a death at some point in the foreseeable future. Exact timings are tricky, we might want to come back to that. But therefore, I think it's quite difficult to actually specify these diseases are going to cause death and these diseases are not, because in both directions, that could potentially be misleading.
So, can you just perhaps talk a little bit further about whether you perceive any difficulties with having a definition of terminal illness within this Act, and how do you think the medical profession are going to interpret that?
Most, so at the extremes, and most people are at the extremes, it is very clear what's going to happen. So for most people, you can say with confidence that barring some extraordinary accident, like you're hit by a car on the way out, you'll be fine in a year, even though you have heart disease or cancer or whatever. At the other extreme, there are people who are clearly dying and will die in the next 2 or 3 days, and there's virtually nothing that's going to change that reality. What we're talking about in this Act, of course, is a point between those stages, but people definitely reach a point where there is now going to be an inexorable and I think importantly for this bill, unreversible slide towards a point of death. And people can make a reasonable central view, if they're experienced in a particular disease, about when that death is likely to happen, accepting that there is a spread around that. And I'm sure that the general public and members of Parliament fully accept this. This is not a precise science. This is a central view, and there's a big academic literature around this. Some people will die significantly earlier than they're predicted to. Some people will die, and a small number will die very significantly later. Some people will certainly die a bit later, or to some degree later. But the central view, I think, is usually reasonably accurate, that someone is now in a point of a pathway from which there is not going to be a return.
Thank you, Chair.
Better.
Thank you, Chair. Thank you for coming and giving evidence this morning, gentlemen. I'd like to pick up a little bit more around coercion and capacity, because I think these are two really important points in terms of the bill. And I'd like to know a little bit more about the work that doctors and nurses do in terms of checking for coercion and assessing capacity when patients are making really important decisions and choices at the end of life, but also maybe in other contexts as well. And if you think, I mean, we refer to the Mental Capacity Act in the bill. I mean, the Mental Capacity Act is a big piece of legislation, but I'm very conscious there's only a short reference to it in the Act. If there's anything you think we could add to the bill that would maybe improve the robustness of that reference to mental capacity. So what does it look like now, and is there anything you think we could add?
Duncan, why do you take the first bit and I'll take the second?
Yeah, so I think just in terms of looking for signs of coercion, etc. So we all of our nursing staff, all of our clinical staff have safeguarding training, and that already looks at things like, are people being under financial coercion, for example, or other forms of abuse. So that training is already in place and is extensive across the NHS, across social care. So I think if the bill is passed, we will need to look at how do we strengthen that in relation to spotting the potential signs of coercion in this space as well. So, but that given that mechanism is already in place, I think that would be an extension. So it's important that we factor that in. And I'm also mindful about, given the scale of that, given the scale of colleagues that we have working across health and care, that the time between if this Act is passed and the implementation is sufficient that we enable everybody to receive that additional training if it's required.
Yeah, I think in terms of strengthening the bill, I mean, I was, as a practitioner, relieved that the decision of this bill, if it stays in this way, was to stick with the Mental Capacity Act for two reasons. The first of which is this is used up and down the country by doctors and nurses every day. They know it, they understand it. Although, as you say, it's a large piece of legislation, it's one which people have worked through in practice multiple times. And if you ask 6 or 7 doctors, does this person have capacity, in almost all cases, then you'll get 6 or 7 identical answers because people are used to using it. It additionally has the advantage it's been tested in the courts. So this has gone as far as the Supreme Court, and the various sort of ambiguities that inevitably were in the legislation there have been clarified by senior judges, therefore meaning it feels to practitioners like me a piece of robust and predictable legislation. Within it, it's very important that there are some situations where you will need to call for additional assistance. So, for example, if someone has a coexisting mental health condition, you would probably want to ask additionally from a psychiatrist, is this interfering with the decision that's been taken to the point that someone loses capacity for this very important decision? So the level of capacity has got to be reasonably high. So my own view is that starting with this is the sensible thing to do. That doesn't mean there couldn't be arguments for some additional points around it, but I can't immediately, again, as a sort of jobbing doctor, see ones where I think this is going to make a big difference. It's the fact that there is a very established bit of well-used and well-recognised legislation that this is founded on.
And if I may, Chair, just to follow up on that, and to that point, in terms of those conversations where patients are making very serious decisions, it's not uncommon that you would seek additional advice from other professionals, such as a
Correct.
psychiatrist, possibly such as a social worker, such as other professionals, if you felt there was a need to do so.
The further you go up in terms of the seriousness of the decision, the more you would do that. So if you were, for example, setting a finger that are broken, you're not going to wait until a psychiatrist has said you can do that. Within reason, you can, provided someone gives consent, you'll do it. If you're going for open heart surgery, or if you're going for declaration of liberty, those kind of things, you'll be much more cautious about moving forward if you think there is uncertainty. But it should be clear, for the majority of people, it's either very clear they have capacity or very clear they do not. Yeah. There's a relatively small number, important number, in the middle where that is less clear and where additional views, particularly if there's a question of coexisting mental health issues, are relevant. The fact of a mental health condition does not in itself mean someone has not got capacity, but it has to be taken into account, and they do have the capacity for this decision at this point in time, which is how the Act actually works.
Brilliant, thank you.
Rebecca Paul.
Thank you, Chair. The bill sets out that it should be brought into force within 2 years. If the intention is to provide assisted dying through the NHS, can the NHS be ready in time to deliver this service equitably and safely? And what needs to be deprioritised in order for it to do so?
Well, I think, as was seen in COVID, the NHS, like any service, can swing very fast if there is a need for speed. In this case, I think most people in society would say the key thing is to get this right. So I personally, I would rather this wasn't running against a timeline. You wouldn't want it to drag on forever because then you have uncertainty for everybody. But certainly I think Duncan and I would both say, 2 years seems a reasonable starting point, but some things might take longer than that to work out how we're going to provide this in the most safe, equitable way, dealing with minority and other groups, for example. We need to get all that right and at least at first pass, get it as close to good as we can possibly do so. Equally, and this is why I hope that some of the more operational issues are done for secondary legislation and regulation, we may find when we first start using it, there are some things we hadn't considered at the beginning, and that therefore we need to go back and improve on because we just hadn't thought about it in the first way through the gates. And that's true inevitably for many bits of legislation, but that's particularly important here. And I think I go back to my very first comment really. The central person here is a person, an average citizen in their last 6 months of life. What we don't want is a system that is very difficult for them to navigate, so they spend their entire last 6 months of life, if this bill is passed and they choose to take account of it, which is going to be a minority, essentially stuck in a bureaucratic thicket. We do need to keep this simple, And my view is the best safeguards are simple safeguards. So overcomplicating actually usually makes a safeguard less certain, to be honest.
So in your view, what is a reasonable time frame? And I appreciate it's a little bit how long is a...
What
would you ideally like to see in terms of...
I think that there's a big difference between the Act coming into initial force, i.e. this is now where the law is, and the service being provided. And on the second of those, I would argue against putting a firm deadline on it, with a reasonable expectation that the NHS and others should be involved in trying to make plans for this as fast as possible. But I think if we're sort of 3 months away from being able to actually get something sorted out, given there are multiple different things we're going to have to sort out to get this to work if the Act is passed, I wouldn't want to have a sort of it must start on the following day, because I think that would make it much harder to provide a safe, fair and secure service. Duncan, you want to add to that?
Well, I think just to add, I think my understanding of the bill, it doesn't specifically call out the NHS as the specifically in terms of providing this service. So I think there are a number of steps that would have to be go through to understand the implications of this, the operational implications, the training implications, as we've already discussed, to understand the timeline required. But, I think for the reasons Chris has outlined and earlier thinking about the wider implications for the workforce, it would need to be a sufficient time to be able to work through those.
So would it be fair to say you would need to know fairly quickly whether or not it would be provided through the NHS for planning purposes?
I think that is a key question. And I think, actually, to me, that does seem something which Parliament may want to debate. That's not a question for us, but that is a point of principle, I think, one way or the other.
Thank you. Thank you.
Ms. Saville.
Thank you very much. Question to Chris Whitty, because as you said, you're here representing the Chief Medical Officer of Wales as well. Health has been devolved, of course, for over 25 years. What conversations have you had with the Chief Medical Officer of Wales about the differences in how the NHS operates between Wales and England and the implications for us to know as the Bill Committee?
I think that, firstly, I've had quite a lot of conversations, not just with the Chief Medical Officer for Wales, but all the other Chief Medical Officers, and indeed a much wider range of the medical profession, because this is something I wanted to feel I was giving a central view of the medical profession in terms of the practicalities. My view is the principles of the bill, in a sense, are no different between England, Scotland, Wales and Northern Ireland, although this is only England and Wales that this would apply to were it to be passed. The operational kind of questions we've been talking about will be either subtly or importantly different between the different jurisdictions for a variety of different reasons. And I don't think that is a problem, provided it's in secondary legislation and it allows the different jurisdictions to actually do it in the way which best suits their own setup. Because, and again, as we saw during COVID, different nations will choose to do the same end state using slightly different practical routes.
Okay, so if I could just develop on that a tiny bit, in the sense of the timeline, in that case, you would see that possibly being different, say, for England, for Wales, in order to respect and take account of those operational differences?
Yes, I think in principle it'd be better to be as close as possible, but I think if there were important practical differences as to why it's not going to start on the same date, the more important question is to get it right, rather than to get the simultaneous timings.
Daniel Francis.
Thank you, Chair, and thank you, gentlemen. I hear what you've said already regarding capacity. Of course, the Medical Capacity Act relies on the three capacity principles, which is the presumption of capacity, that a person can't be held to that capacity unless all practical steps have been taken to support them to make the decision, and that a person cannot be held to that capacity merely because the decision is unwise. And I also heard what you said about that scaling of decision making, but of course within the Act, in some of those scenarios there's no mandation, the word may is used rather than the word must. So I'd like to understand your viewpoint on whether those parts of the Act were taken and tightened for may rather than must, and whether there's a definition of ability, which is within our amendments before us to delete the reference to the Capacity Act, instead have a separate definition of ability, if that were to be there, whether you believe that would provide stronger safeguards.
I think the exact drafting of the bill in terms of may and must is probably, I'm not the best person to ask, but I can ask the second part of your question, which I think is really, really important. Were there to be no Mental Capacity Act, I think there would be an argument, which has been used for a long time. I think this bill would clearly have to define what was meant with a fair degree of clarity, and it wouldn't be able to do it with just one clause. It would have to be quite a lot of clauses, if I'm honest. The reason why all systems of this sort are going to be imperfect, the reason I think it is sensible to base yourself on the Mental Capacity Act is it is well used and well understood in practice by practitioners every day. To have a system where you have two completely separate groups of assessment, one of which has never been tested in the courts and has never been used out with this, would, I think, lead to a whole set of potential complications and ambiguities which are not there because we've got a well-tested mechanism through the Mental Capacity Act. So I think people should move away from the Mental Capacity Act with some caution, because I think it will cause as many problems as it solves. And it's not clear to me what the problem is that people are trying to solve by doing this, given the Mental Capacity Act clearly makes the point that the more severe the decision, the greater the degree of capacity has to be assumed before people can actually take that decision, which I think is at the foundations of some of the disquiet that people have had. But that is very, very central to how the Mental Capacity Act in practice works.
Dr. Sanderson.
Thank you. You've already said some words about prognosis, because that is causing some anxiety with this bill. First of all, are you happy with a 6-month prognostic period? And secondly, in the Act it says reasonably to be expected within 6 months. Are they in line with your thoughts on this matter?
I think, provided that Parliament, in taking that into account, assumes that what we're meaning is a central view, that this is 6 months, but it might be before that and it might be after that, but this is a central view, I think that is a reasonable point in time. Other times it would equally be reasonable, but if you're going to choose one, this is a reasonable one at 6 months. It is generally very predictable someone is going to die in the foreseeable future. Whether it's 5 months or whether it's 7 months is a lot harder, and there'd be some caution. And notably, in those countries that have chosen to go down the path of an assisted dying route, a variety of different ones have been chosen, a significant minority of people die before they actually get to the point where that occurs, because there is uncertainty in both directions. But I think it's as good as any other, but I just want people to be clear that it's not an exact science where you can say on the 20th of August, it's not like, for example, it's not as tight as, for example, saying that a baby is going to be born on this date. It has a wider spread of uncertainty around it. But it doesn't mean that, in the overwhelming majority of cases, that doesn't mean it goes on for months and years longer, but there will be some degree of uncertainty.
Okay, thank you. Can I have one more question, Chair? I'm just interested in the opt-out, that doctors, ethically can opt out of to taking this decision for patients. What I'm interested in, should they then have a necessity to steer someone to another doctor, or can they just simply refuse to do it?
I think that is so. Duncan may wish to comment for nurses. For doctors, I think that we should be very mindful of the fact that for some doctors, as for some citizens, this is a point of very strong principle. Indeed. And therefore I think there will be a gradation of people's feeling that they can personally be involved in this. I suspect for the majority, probably the great majority, referring on if they themselves don't feel able to do this, either because of conscience or choice, or indeed because they don't feel that they have the necessary skills, I think they would have no problem. But for some people this might be an issue. And personally, my view is we should be able to have the range, provided people are aware in general that if one person cannot provide it and does not wish to discuss it, there are alternative routes. But that really is a matter for Parliament. And if Parliament says that's unfair on the patient, because then the patient is having to go through an extra step, that is an alternative and perfectly reasonable principle. So I think Parliament is going to have to balance those two principles. It's not for me as a doctor, but I just think that range of opinion needs to be thought through when people are coming to that final parliamentary decision.
Yeah, if I could just add to that, I think it's really important then that, again, that bit about the wider workforce and how would we support them. That we have situations like this already where, we've got advice professionally around things like abortions and working in embryo services, for example, and so and fertility. So we need to make sure that the safeguards there for our staff are really clear, because as Chris has said, you know, we will have a range of views and opinions amongst our staff on this, as there are in the wider public. And so I think that the work you do in creating this bill is really important in terms of what advice do we give to people about signposting and, you know, having those conversations where actually our clinicians are having conversations every single day about the choices that people have at the end of their life.
Thank you, Chair. Professor Chris Whitty, you said not all mental capacity assessments are safe. Do you think hopelessness, low mood can lead to people's ability to make capacity, and a sudden diagnosis of terminal illness can lead to some of the status, depression, low mood, hopelessness? And do you think all doctors are capable of identifying those states?
So I think that I would hope that most doctors are capable of identifying that someone has some degree of, or a large degree of mental health distress or mental health illness, if you wish. What not all doctors will feel comfortable doing is actually deciding whether that is sufficient to interfere with someone's ability to make a decision with full capacity. And that's where help from colleagues from psychiatry, mental health more widely is going to be useful. But that should be good medical practice in my view under all circumstances. This bill takes it to a high level of need because of the seriousness of the decision that's being taken. But that is part of, you know, I will in my medical practice, Duncan will discuss with senior nurses when he was operating clinically, you know, should we actually get an opinion from a mental health, either community psychiatric nurse, if it's that kind of question, or a psychiatrist or others, to make that assessment. But that's really the question. But certainly what I wouldn't want is to be in a situation where the existence of the fact that someone who has a terminal diagnosis has some degree of low mood in itself just rules them out from any kind of medical intervention, this or any other. That shouldn't be the case. They've got to have access to whatever the state and the medical profession are able to provide, depending on, again, obviously what Parliament decides on this particular bill.
Can I ask a question to Duncan, please? Thanks, Duncan. Nurses who work in stressful environments are expected to get clinical supervision, like people who work in mental health wards. Do you think the nurses who are going to work, if this bill passed through, in those areas would require a specialist clinical supervision? And do you think the NHS have capacity to provide clinical supervision for the nurses who is going to work in those areas?
Well, look, I think you're absolutely right. Anybody working in stressful environments, and if we were to have nurses, doctors working in services, if this bill is passed, then they will need to we will need to make sure that we've got sufficient psychological support for those individuals, as we do now for many of our nurses and other professionals that are working in these kind of situations in terms of end of life, or, you know, cancer nurses, for example, often have psychological support to help them deal with some very difficult conversations with patients. So we would need to look at that and to make sure that there is sufficient support in place for anybody working in these situations, and also mindful about the wider workforce and the issues that such a debate as this and you know, the decisions that to signpost people onto services and how that might create for some people moral injury. So we do need to think about the support that's in place for those.
Thank you. You touched upon it, but if I could just get some further clarity perhaps. Certain amendments have been suggested which essentially are more prescriptive in what clinicians, factors that need to be taken into account and steps that clinicians would have to take when considering capacity in this context, but also informed consent and what options are available. Of course, it's a matter for Parliament, but would you err on the side of trusting clinicians' professional judgment within the legal framework as it is, in terms of the Mental Capacity Act, in terms of the guidance on informed consent, or would you deem it suitable for further prescriptive steps to be put into primary legislation in this context?
Entirely a matter for Parliament at one level, but I can give a view.
Yes.
And I think it actually goes back to the point that Naz Shah and others made earlier on. The situations people find themselves in are extraordinarily different. Culturally, where they are in their lives, where their families are, a whole variety of other issues. And only the clinicians who are dealing with that person really will know all the different factors that are playing. And if they're doing, if there's a good therapeutic relationship, which you certainly would hope there is, they should understand a whole variety of things which are very difficult to predict for people sitting around this table, however wise you are, and I'm sure extraordinarily wise, to be clear. That wasn't my point. My point is it's very, very difficult. I could not, at this point, write down a law that would actually be helpful to someone dealing with a whole range of different scenarios where they're going to have an end-of-life discussion. So my own view, for what it's worth, is I would do fewer rather than more, and that is partly because simplicity is the key to really good safeguards, in my experience. If safeguards are really clear and simple, everybody understands them, and if you ask 6 people, what does this mean? 6 people will give you the same answer. The more complicated you give things, the more room for ambiguity and uncertainty, because different things are playing in, the more difficult it is for the patient, their family, and those medical and nursing professionals who are assisting them actually to navigate systems. So I think, without in any sense wishing to curtail what Parliament might wish to do, I would make a plea for simplicity wherever possible, and for accepting the extraordinary variety of people's lives, which may have unpredictable consequences in terms of the way that the end of their life plays out.
And so just in terms of setting standards and ensuring universality of understanding those safeguards, that's better done, in your view, then by training, by guidance, rather than primary legislation setting up factors?
I would certainly recommend that this is, if possible, is either done by guidance or done in secondary legislation, which, if it then turns out it's not having the desired effect, can be adjusted to change that. Because two things can change. First of which is we can spot some things we hadn't thought of in the first place, however far-sighted each of us is. But the second is medicine itself changes, the diseases people suffer from changes, and so on. And an act has to be durable, and that's why I think, in my view, secondary legislation and guidance has the ability to adapt in a way primary legislation is much more difficult to adapt. So that the really fundamentals need to be in primary, obviously, but these kind of issues, I think, are often better done in secondary.
I'm very mindful of the time. It's now 3 minutes past, so this will be the last question, I'm assuming, of this session, and I'll go to Jack Abbott.
Thank you, Chair, and thank you, Professor Whitty and Duncan, for being with us this morning. Professor Whitty, in October you published an advice note to doctors about a range of guidance on this issue alongside a number of chief medical officers. In there you've said that a couple of things are unanimous for the medical profession, but the one I'm kind of focusing on is the line where it says that we must not undermine the provision of good end-of-life care for all, including the outstanding work done by palliative care clinicians. Do we take that by implication that you're fearful perhaps that this bill could indeed do that it could undermine good end-of-life care? And in your view, how might we be able to mitigate against some of those risks within the bill before us at the moment?
I'll give you, and Duncan will also articulate it. The Chief Nurses did a parallel bit of advice which said similar things. I think all of the medical profession, all of the nursing profession, all health professionals very strongly believe that palliative care and pain alleviations, which is not the same as palliative care but overlaps with it, and end-of-life care, which is also not the same but overlaps with it, are essential, and in some areas are not to the high standard that we would hope for. And I think that would be common view across the medical profession. My own view on this bill is, my hope is that it will should not either make that situation better or worse. I think it changes one particular aspect in a very important way. But the principle that we should be improving end-of-life discussions, which is where the end-of-life care starts from, and supporting further the provision of alleviation of symptoms and palliative care, seems to me one that I don't think would have any disagreement from anybody in the medical, nursing or any other professions, or indeed the general public. And I think that must be fundamental to how this bill is sorted out.
Order. That brings us to the end of this allocated session.
Do you want to say you agree or disagree?
For committee members, but I will let you say a few words if you wish to, Duncan, but that was the end of this session.
I absolutely agree with that. I think, obviously this is a decision for you, but what is clear is that discussion around death and dying in society has increased, and I think that's important. I think it's important that we have discussions and support people with their choices at the end of life. So I think anything we can do to increase that is important.
I want to thank our witnesses on behalf of our committee members here, Professor Sir Chris Whitty and Duncan Barton, and also thank the members for their short questions. Thank you very much indeed.
Thank you.
Okay, who's want to indicate for the next set? Okay. Okay, I'll start with the people I didn't get in on the last one. Okay, we're ready. We will now hear oral evidence from Mark Swindell, who is Assistant Director, who is Standards and Guidance at the General Medical Council, and Dr. Andrew Green, who is Chair of the Medical Ethics Committee at the British Medical Association. For this session, we have until 10:45 a.m. So could the witnesses please introduce themselves for the record and give a brief statement? And we start with you, Mark Swindell.
So I'm here from the General Medical Council, and the GMC, as the independent regulator of doctors across the UK, doesn't have a position on what the law overall should be on assisted dying, and similar to what the Chief Medical Officer said, we view it as a matter for wider society and ultimately Parliament. But having said that, we have looked at the bill, and were it to pass, we'd be obviously willing to work on things like the statutory code of conduct that it talks about to make sure the implementation works as best possible.
Thank you. Good morning. My name is Andrew Green. I'm a retired GP, and I chair the Medical Ethics Committee at the British Medical Association. We had a very big survey of our members in 2020, and on the basis of that survey we moved our position to neutrality. All that means is that we neither support nor oppose any changes in legislation. What that position has enabled us to do is to reach out to people with a wide range of views and produce policy that we believe has broad support, looking particularly at the areas where it impacts on our members. We've had very positive engagement with legislators throughout the United Kingdom, and indeed in the Crown dependencies too, with the aim not of supporting the bills, but with the aim of making sure that if a bill does go ahead, it works for doctors and for patients, because we've always believed that those things go hand in hand.
Thank you very much indeed. And just for broadcast purposes, can everybody make sure that they're as loud and clear as possible? So I call Dr. Neil Shastrihurst.
Thank you, Chair. Good morning, gentlemen. If I can turn to the issue of the initial discussion, which is dealt with at...
Another tick box thing that doctors mentioned to patients that must not happen, and that's why we believe that it shouldn't fall within those two Supreme Court judgments that you mentioned. But there is another side to that coin, that we think that there are some circumstances where doctors should be able to mention this to their patients. If I can just explain why that might happen. Within the consultation, some patients do find it very difficult to bring up with their doctors sensitive subjects, even when they're the most important thing on their mind. And doctors are aware of this, and I hope we get very good at reading between the lines of what patients say to get at what's left unsaid. And in those circumstances, we need to be able to open the door for the patient to go through into a safe space to have those difficult discussions. And that's what we're talking about here. It's very difficult as a clinician to know when to have those conversations. The last thing that we would want when we're battling with that internally is to feel the weight of legislation behind us. So please do not pass legislation that makes it harder for doctors to understand their patients, because that's why it's important that in particular circumstances we should be able to gently raise the subject.
Yeah, if I could just add, so the GMC sets guidance on decision-making and consent, as you'll know. That is based on the existing law, including the case law on Montgomery. So it does put a lot of weight on patients having autonomy and their role and the doctor's role to support that in the provision of information on different options, including the option of no treatment. But our guidance follows the law, so were the law to change, it would very much, we would look at it and accommodate. So we don't have a formulated view on what the eligibility should be, but we do know the BMA's stance.
And from the Sorry, Chair. And from the GMC's point of view, have you undertaken a legal assessment on the openness of a legal challenge around that Montgomery point, if those conversations were not initiated and patients saying that they weren't given the full options available to them?
No, we've not done a forensic legal assessment of that nature, but obviously Montgomery's in case law, and what Parliament does have the power to set primary, but I listened to what the Chief Medical Officer said and what Dr. Green says in terms of how restrictive that might be or otherwise in terms of the doctor's role with the patient.
Thank you. Just might sound a tiny bit of a devil's advocate point, and fully appreciating you don't want to reduce this to, as you described, a tick boxing exercise. I guess the risk of what you're sort of describing, perhaps some may argue, though, is an element of a lottery, though, because obviously if you're relying on doctors to use their personal judgment as when to have that conversation, let's say, for example, the patient and the doctor don't have a particularly close or long-standing relationship, the doctor may not know what those signs are, as you describe, and so a patient who may need to have that conversation may never have it. So I guess the risk is you're relying on actually good relationships forming over time, a doctor to use their intuition. So actually the risk that opens up is that some patients will have the conversations they need to, others probably won't under the kind of system that you may be describing, I guess.
And obviously it would be great if we worked in a system where doctors had all the time they needed to deal with the patients. One of the things that we would like to see, there is a mention in the bill of a duty to provide information from the Chief Medical Officer, I believe. Reading the bill, to me it seems very much like this might be in the form of a website or leaflets. We actually believe it's important that patients should be able to access personalised information, and we would like to see an official information service set up that patients could go to either as a self-referral or as a recommendation from their GPs or other doctors that would be able to give them information not just about assisted dying but about all the other things that bother people at this stage of their life. So social services support, the ability of palliative care. They could almost be like a navigation service as much as an information service, and that might address some of the concerns that you have.
Thank you. Our previous witnesses, the issue of coercion came up, and our previous witnesses were very much talking about GPs and doctors and nurses should be able to sort of spot it because of the level of training and experience, etc., etc. I'm just wanting to sort of get a judgment from you as to how frequently sort of coercion or lesser versions of it, familial pressure, societal pressure, is a part of day-to-day life for a medical practitioner, or is it something like with my asbestos awareness training that I had in the previous job, where I had it because I'm occasionally, very rarely, I might bump into it, or it's a tick box exercise?
You're right, all medical staff have safeguarding training, and of course patients make important decisions often with the influence and the help of their family members, and usually this influence is helpful, and it almost always comes from a position of love. The point at which influence like that becomes coercion is a difficult one to find out. My experience is that it is rare. I would recommend that you look at what's happened in other parts of the world that have more experience of this, because they have got, as part of their training, modules on this, and certainly we would expect capacity and coercion training to be part of the specialised training that doctors who opt in would go for, and I would anticipate that the general safeguarding training should be sufficient for other doctors who would only be involved obviously at that very early stage.
I just wanted to talk to you a little bit about the process. I've been searching for kind of parallels in current practice, and I guess one that seemed close to me was if I wanted to donate a an organ, a kidney, to a relative. Now, as I understand it, in those circumstances, first of all, the doctor is able to raise that possibility, even if I hadn't thought of it, at the front end of that family decision. But then coercion and capacity are then assessed later by a trained individual. Would it be possible, do you think, to translate both of those into this situation? And then my second question was, as I understand it, the GMC already has guidance on dealing with assisted dying if raised by a patient, how doctors should handle that, and how easy how easy would it be for that guidance to be translated from what struck me as a kind of not hindering but also not enabling process towards something that was more informative?
Yeah, it's important to our guidance on assisted dying is framed in the current law, so it guides doctors to explain to the patients that that's not lawful for them to assist their patient to die, and it talks about the importance of explaining what other treatment options are available, including palliative care, and making sure that the patient's needs are met, and any other safeguarding matters. Our guidance does follow the law, so if the law were to change, we'd obviously attend to that. But it's not framed quite as you're suggesting that it assists doctors. So I wouldn't think that would lift and shift into what the guidance would need to be for doctors if this were to pass.
I don't have any experience with what you're describing, but certainly it would make sense to look at best practice in other areas.
But you're clear, though, that doctors should be free to have an open discussion with their patient about the whole variety of possibilities or paths that may be available to them as they face a terminal disease.
As a general principle, I don't believe that unnecessary barriers should be put in the way of communication. This is such an important area for patients that it's vital that they form a good, trusting relationship with their key medical advisor, which would usually be a doctor. I also have to say that we have, at the end of life, we depend a lot on our specialist nurses, Macmillan or Marie Curie nurses, and it might well be that they're the person who the patient trusts most. But please don't put barriers in the way of understanding.
Because, I mean, just to add, sorry, Chair, we in the run-up to second reading, we did hear from some of the overseas experience that where there'd been effectively a kind of gag clause on doctors, it was proving to be extremely difficult and a big barrier for the medical profession, it felt, to discharge its duties. And you would recognise that issue.
Indeed, and I believe that in New Zealand, and I think it's the state of Victoria, I'd have to check that, there have been official reviews that have identified those concerns, and they're looking to review the legislation.
Okay, thank you.
Thank you. Just quickly on that last point, although it's noteworthy that in Australia and New Zealand, palliative care professionals are very keen on retaining that safeguard to ensure that it is not suggested to patients that they might have an assisted death unless they've brought it up themselves. So I think that's worth noting. And quickly, I've got a question for each of you, but just a quick clarification from Dr. Green. Is it my understanding, in terms of the survey, the official position of the BMA to be neutral? The majority in favour of neutrality, moving away from an opposed position, was the junior doctors and those not working with the elderly and the dying, whereas the great majority of doctors who work in palliative care and work with dying people remain firmly opposed to a change in the law. Is that your understanding?
There were some variations between specialties, that is true, but within all specialties there was a wide variety of opinion, and it's that wide variety of opinion that the BMA has based its policy on.
I understand. Thank you. Just a question for you, Dr. Green, on the delivery of the service, if it's brought into law. Is your understanding that the bill mandates the NHS to provide assisted dying service? I mean, appreciate that it's not clear in the bill, but nevertheless it does authorise the government to pay for it, and it establishes this right. So my question to you is this a medical procedure that we are proposing to legalise, and should the NHS provide it? And if the answer is yes, should that be a separate service within the NHS, or should that just be part of general practice?
We haven't taken a view as to whether it should be inside or outside the NHS. That's not for us to take. We do believe that it should not be part of any doctor's normal job to provide assisted dying. In other words, it should be set up through a separate service with a degree of separation. We believe this is important for patients, because it would reassure patients who may be anxious about the service that it wouldn't just be part of their normal care. It would reassure patients that the service they were going into had proper quality, proper audit attached to it.
Okay.
It would reassure doctors, because doctors who didn't want to have any part wouldn't feel that it was part of their normal job, whereas the doctors who wanted to go ahead would be assured of having support, emotional support and proper training. And also it should hopefully reassure the providers who would then be assured that it wouldn't be expected of them just as part of their normal duty. So a degree of separation, we believe, is very important.
Okay, and quite quickly, if you would, what are the implications for resources then? Are you concerned? I appreciate that's your view, and I recognise it. It makes very good sense. Are you concerned about resourcing of that service and in terms of whether there might be implications for other parts of the NHS if this was to be a separate service?
I think we're always concerned about resourcing, and I can only back up what Dr. Whitty said about the importance of palliative care.
Okay, thank you. Mark, if I can come to you just quickly with a question about the actual end, the final act, as I think it's called in the bill. Do you think there needs to be more specific guidance on the face of the bill or in a schedule about what should happen in the case of complications? If the death is taking a long time, it can take up to an hour quite commonly in other countries. There may be complications again, that happens. What would happen if a doctor were to intervene to genuinely assist the patient to die if something was going wrong? Are you worried about the legal implications for doctors in those circumstances?
I would agree with you that there certainly needs to be really clear guidance for doctors on that scenario. What we've not taken a view on is whether that needs to be on the face of the bill or in regulation or in the statutory code of practice. What I would say is we'd be willing to participate in the setting of that, and I think it would be very important to listen to the view of doctors and indeed patients who might be interested in taking such a course of action to understand.
And just very quickly on that last point, it's not totally clear what kind of medical professional would be in attendance at the end. Do you think it should be a fully trained doctor? Should there be some separate professional with that role? How should that work?
I said not trying to duck the question, because we don't take a general view on whether the bill should pass or not. We've not taken an established view on the delivery mechanism for it.
Thank you. Thanks.
Thank you, Chair. Two areas. Can I start one with in terms of the current law? So I suppose I'm interested in the position that doctors are currently in, the regulatory and whatever around the current law, which clearly under the Suicide Act, etc., prohibits this. So we've heard a number of us from families who've gone to Switzerland perhaps with etc., and who've returned and had a conversation with their family doctor around maybe the death of a loved one. We've got instances, I think, of people attempting to take their own lives, given there's no current assisted dying provision in this country. I wonder if you could just say a little bit about the current dilemmas facing doctors on the current law as it stands.
Yeah, so we do get inquiries from doctors concerned that they're doing the right thing when it might become apparent to them a patient is wanting to travel overseas to access assisted dying. We've taken legal advice and on the basis of that we guide doctors that it's permissible for them to provide the existing medical records to that patient, as you might do under, say, a subject access request, but to be really cautious about going any further in terms of things that like recommending that or assisting the process more than that, just based on our understanding of the existing law in the Suicide Act.
And of course, if I may, that leads on to a further issue that we've heard from Dr. Whitty today, that this may progress at a different speed between Scotland and England and Wales. And of course, we also have the Crown dependencies who are some way further ahead than either of the mainland governments on this. And this does raise an issue for doctors who work in England and Wales who treat patients in the Crown dependencies. And we would want clarity as well about the legal situation regarding a patient in Liverpool who is treating a patient in the Isle of Man. Should the law allow assisted dying in the Isle of Man?
Thank you. And moving on to the next issue, I think you both said, I think, fairly clearly around or advocated against having an absolute ban on doctors discussing this or raising this. I suppose I just want to tease out, is there a difference between raising it and recommendation? So I think Dr. Green, you suggested maybe it might be appropriate for a doctor to recommend that someone seeks further information from an independent source, for example. If Parliament so wished, do you think it would be appropriate for Parliament to be clear that no doctor should be recommending assisted dying as a course of action?
I don't think I ever suggested doctors should recommend assisting dying. If I did, I apologise.
No,
it was a
information, the provision of information for someone that was...
The provision of information would be very useful, because in a situation where a doctor was unwilling to have an initial discussion with the patient, it would provide a way for the patient to get that information which was in no way obstructive.
So, okay, I'm just going to try again. So, some people are advocating that there should be a ban on this being discussed at all, which I think we've heard your answer on, both of you. I suppose a different version of that, a slightly different version of that, is a ban on any sense that doctors would recommend this as a course of action in the way that, say, an oncologist might recommend a course of chemotherapy. And I wondered if you could comment about that as a potential approach to assuaging some questions or concerns of the public on this, and how that would sit in terms of regulation.
We've not taken an official view on doctors recommending this, but I don't think it was ever in any of our minds that doctors would be recommending this as a course of action to patients.
So you would be happy if there was an explicit prohibition on recommendation?
I'm reluctant to make a statement on that in this forum. We will go away and discuss it and come back to you.
Thank you, Chair. Question that applies to both of you regarding clause 2, with the first doctor and the second doctor. Both doctors are required to, so for the first doctor, required to determine the patient has a terminal illness, second, capacity, and the third one is not being coerced or pressured. And again, for the second doctor to make sure that the patient has a terminal illness, has capacity, and again, not coerced or pressured. I appreciate that Chris Whitty talked about doctors, and yourselves have talked about everybody being trained in capacity and coercion issues. But these doctors might never have met that person in the first instance who is now seeking assisted dying. And the questions that worry me, to be able to perform all of these actions in all cases without fear of misdetermining, the two doctors would have to be specialists in the relevant disease. So, for example, if somebody has a brain tumour or it's lung cancer or different types of cancers, would they have to be an expert in that to be able to determine that they're terminally ill? Or would they, from the GMC's point of view, would we find ourselves in a situation where doctors are working outside of their professional competence and expertise? That's one point. And from the BMA's point of view, how do you protect doctors from finding themselves having to diagnose life expectancy for a disease they are not specialists in, and for determining capacity when they are not specialists in that, and determining lack of coercion when they potentially don't know the patient and don't have the experience of that. And finally, for both of yourselves, when the next step is taken and the court has to rely on the testimony of these doctors to protect the patient, are those testimonies, given all of these concerns, then safe to be relied upon by a court and by a judge?
Okay, so there's quite a few points there. Actually, working backwards, we have some existing guidance for doctors when they act as a witness, for example, in a court setting or other medical legal situations, and that talks in general terms about the importance of you being an appropriate witness. So inherent to that is some expertise and understanding of the topic you're assisting the court on. So I would suppose, again, that those sorts of principles would be ones that, if the bill passed in this form, and say again, the GMC's not got a view on what the sort of delivery mechanism or the bill should look like, but there may be applicable points from that guidance that would read across. I think you heard from the Chief Medical Officer about his caution about going down a condition-based assessment for this sort of thing. We wouldn't have a particular view on that, but there is one thing I wanted to highlight from the bill. It talks about specialism in the context of seeking advice from a psychiatrist. In terms of the GMC, the specialist register that we hold, there are actually 5 specialisms connected with psychiatry, so some clarity about is it any one or one particular one of those that the bill intends to cover would be good. I know that's not restricted in terms of the independent and doctor and the coordinating doctor roles from the bill either. But also we're aware that when doctors pursue a specialty in the sense that they become accredited and they go onto our specialist register, that doesn't fix in time what their individual scope of practice or expertise is. We know many doctors will go into slightly different fields or focus on one particular area. So one can't necessarily rely on the specialist register as a current indication of a doctor's area of competence in that way. What the precise delivery mechanism is and the point you make about, should either of those 2 roles of doctor have seen the person, because we've, again, not taken a view on what the law should be. We haven't taken a firm view on any sort of process or eligibility, but I know the point.
Thank you. If I may, I'd just like to clarify my previous answer, having a little bit more thought. I do not believe it is ever appropriate for a doctor to recommend that a patient goes through assisted dying process. My internal thoughts was whether it should be on the face of the bill or contained in guidance or contained in good medical practice is the point that I was unsure about. With regards to the specific questions, no, I don't believe that a doctor has to be a specialist in the individual disease at stake to advise a patient about prognosis. I can only refer you back to what Dr. Whitty said, that in the majority of cases it is fairly clear. This applies to capacity too. There are some cases where it is not so clear, and what's important there is that the doctor has the ability to seek for further advice if they need it. It's not always required.
Thank you.
Dr. Samnover?
A couple of points. Firstly, this in clause 4, subsection 5, it says that a registered medical practitioner, if they're unwilling to go forward with this assisted dying request, must, if requested, refer to another registered practitioner. Are you happy with that clause?
No, we're not, because we know from our survey that there are some doctors who feel very strongly about this, and the word referral to a doctor means writing a letter or communicating with another doctor to see, and there are some doctors who would find themselves not able to do that. So for that reason we believe that there should be an information service and then the doctor could direct there. So there is a particular problem with the word referral, but doctors wouldn't be able to be obstructive. They have the same duties under good medical practice as, for example, they have with termination of pregnancy requests.
Okay, thank you. And the other thing follows on from the previous question, is about the status. Now, I know the GMC and BMA have all other specialties of doctors underneath them. Would it be appropriate, in your view, for example, to have both doctors as general practitioners, or should there be provision for different doctors as a second doctor?
We've not taken a view on the qualifications of the doctors involved. We did have discussions about what grade they should be, for example, but we took the view that what was more important is their skill set and their training than their actual grade or their position.
And sorry, one further. Should there be a period, so in some legal medical situations you need to be post-training for 5 years before you can have a view. Is this something you would have in both of these practitioners, or is that not necessary?
We didn't take a view on that. We thought that training and experience was more important.
Okay, thank you.
Sarah?
Thank you, Chair. Actually, leading on from Dr. Ofer's question there about the must clause, if you like, the must refer. You and Professor Whitty both stressed the importance of the relationship between the doctor and the patient, and yet there may be doctors who feel very, very strongly against recommending assisted dying, not recommending, but mentioning assisted dying. Given the existence of the, I think it was clause 4? Yeah, 5, beg your pardon, and the must refer. Do you think there's a danger that there might be doctors who would actually be reluctant to provide a prognosis of 6 months or less if they thought that that would make the patient eligible for assisted dying, and that simply wasn't something they could support.
That is why it's important that doctors should be able to opt out of any stage of this. There are doctors who would find it difficult to do that, and it's important that their position is respected.
Thank you, Chair.
Want to pick up, I believe, Kim Ledbetter
just
on
on
that?
point, thank you, Chair. Just on that point about referral, what happens in the case of abortion? Because it's one of the closest parallels we can get. So if we have a doctor who isn't comfortable having that conversation, presumably they can't just leave that patient with nowhere to go.
No, so what happened is that the doctor would provide the patient through their receptionist or through leaflets or through a telephone number with somewhere where they could get the information. You cannot just abandon a patient. They have to be sure that the patient has the ability to do what the patient wants to do.
Yeah, exactly. So the terminology might not be quite right in terms of refer, but we're saying we've got to provide that patient with a course of action.
Yes, it is the referral word that is problematic for us.
Yeah, okay, that's very helpful, thank you. And can I just pick up one more point, Chair? In terms of the GMC guidance around information about assistance to die, when that's raised with practitioners, part of the guidance there is that practitioners have got to respect competent patients' right to make decisions about their care, including their right to refuse treatment, even if this will lead to their death. So I'm interested in how that fits in with those very difficult conversations. And when a patient executes that right to refuse treatment, are those cases logged? Is it monitored? Is it reported on or not?
Yeah, so you think there was an important piece of case law, I think, in the 90s that clarified that a patient refusing treatment and subsequently dying that is not an act of suicide. So yes, you're right. Our guidance does talk about the importance of a doctor explaining to the patient about the likely course of action in terms of the option of no treatment. Again, that's intertwined with the Mental Capacity Act, and it puts a lot of autonomy in the space of the patient, along with the consent case law that we covered before. Just on the previous point again about the issue of referral, so our guidance is similar to what Dr. Green was saying, in the case of conscientious objection, for example, on abortion, that the important point is to think from the patient perspective that they're not left with nowhere to go. So if that assists, that may be a principle that helps read across.
And just on that reporting point of where patients take that right to refuse treatment. Again, obviously capacity must be assessed at that point if a patient has said, look, I don't want any more treatment. So that's quite an important point to assess capacity. And are those cases logged and recorded?
Yeah, so it would be important for the patient's records to cover the points of consent and make the doctor's recorded that they've interacted with the patient that way. I wouldn't believe it's centrally held, but I maybe collated in any sense like that. I may be wrong.
Thank you.
Jane Richards.
I just want to get some clarity on clause 4. I understand your this is for Dr. Green. Subsection 5 and the information services, as opposed to the referral to a practitioner. I think that has some weight. In terms of the rest of that clause as drafted, it has an opt-in, it gives wide discretion to practitioners, there is no obligation to raise it. It ticks all the boxes from my understanding of your written evidence. Is that fair?
Yes, with the exception of the referral.
Yes. Thank you. I just want to clarify that. Thank you.
And of course, much of Section 4 we would regard as normal care in any case.
Yes, and there is, sorry, Chair, there is some amendments being proposed which would offer further clarification, more things that have to be considered. A similar question that I asked to the previous panel, I think you were here in the public gallery. Would that be welcome to offer further guidance for your members, or would you again err on the side of trusting their professional discretion?
As Dr. Whitty said, I think simplicity is the key here.
Thank you.
Thank
you very much. Dr. Green, you mentioned the different jurisdictions within the United Kingdom, the Crown dependencies. What issues have your members raised in relation to this legislation?
in terms of the cross-border issues.
Yes.
Yes, I think the concerns are that patients particularly from the Crown dependencies, might be looking for some things, for example, like reports on life expectancy from doctors in the mainland. I think it is clear that if the doctor travelled to the Isle of Man or Jersey to do the work there, then the GMC would be happy with them, but we would want a clear understanding that they would not be at risk of any other legislative problems from, for example, the DPP.
Yeah. And of course legislation is progressing in Scotland, which has different definitions to that which we're discussing here as well.
Correct.
Yeah. With the GMC, I mean, any commentary about the fact that we have health devolved within Scotland and Wales, Northern Ireland, and a different set of jurisdictions in some instances?
So there are aspects where the law will differ, including on capacity, where, as a UK-wide regulator, we've managed to attend to that in our guidance so that, as best possible, we hope that doctors are clear on their responsibilities, where they lie either side of a devolved border. There's a nuanced point with the Crown. So in law, we are a UK-wide regulator. We know that the Crown dependencies and Gibraltar will choose to use doctors who are on the GMC register, but we don't sort of legally officially cover those areas, but we do. It does give us some regulatory purchase there. But if a doctor wishes to remain licensed to practice on the GMC register, there's a commitment to follow our professional standards.
Mindful of the time, this is probably our last question. Surgeon Joseph.
Thank you, Chair. What's your view on the accuracy of prognosis we make in this country? If somebody is told they may live 3 years instead of 6 months, may make a difference to their decision making. Does GMC or BMA have any data or studies done around the accuracy of prognosis?
We don't hold data. I've seen some of the coverage in relation to the bill and the uncertainty. I think we'd agree with a lot of what the Chief Medical Officer said to you about the stepped decision a doctor will make depending on the importance of the situation, and we try and capture that in our end-of-life care guidance, and would agree also the point about a doctor giving a central estimate. In that guidance, we talk about issues, so for example taking a second opinion where there's a greater degree of uncertainty, the importance of doctors keeping up with sort of the latest clinical knowledge and efficacy of different sort of treatment courses to come to that determination. But we would agree there's inevitably a degree of uncertainty in that central ground that the Chief Medical Officer was talking about.
Okay, Mark, we have got a little bit of time.
Just very quick to clarify a bit on this referral issue. As I understand it, I may have it wrong, but in your 2013 guidance on medical practice and personal beliefs, it does say that doctors should refer to in abortion, it should say doctors should refer to a colleague or service provider rather than to a general information source.
I don't believe we use the word refer. We do talk from the. I'll double check that. We do talk about, because referral, and I think this is part of the BMA's position. It has a meaning in the world of medicine. We do talk about the importance from a patient perspective and then not being left with nowhere to go. So there's some professional responsibility on the doctor to guide them.
Because my concern I understand the BMA's concern, but my concern is that kind of here's a leaflet, you're on your own, or you can get information from this place. For somebody who's in extremis at that point in their life might prove to be quite a significant barrier for them, and whether doctors would reflect that in their sense of responsibility towards the patient, and we should leave that open rather than what is currently in the bill.
We would expect that to be done with sensitivity.
Right. So professional judgment again.
Order. If you'd like to complete your sentence, but we have come to an end.
That was my complete sentence.
Okay. Excellent. Perfectly timed. Order. That brings this session to a close. I want to thank the witnesses on behalf of the committee here. That's Mark Swindell, Assistant Director of Standards and Guidance at the General Medical Council, and Dr. Andrew Green, Chair of the Medical Ethics Committee at the British Medical Association. Thank you. And we're all ready with the Zoom. Yes, perfect. While we're waiting, do people want to indicate who wants to, do any of the members want to indicate? Okay. Got the first one? Yep. Got the second one? Yep. Okay, yeah. Oh. Oh, yes. Okay. Got everybody here. Okay. We'll now hear oral evidence from Glyn Berry, co-chair of the Association of Palliative Care Social Workers, via Zoom. Hello and welcome. And Professor Nicola Ranger, Chief Executive and General Secretary of the Royal College of Nursing. Now, for this session, we have until 11:25. So, could the witnesses introduce themselves first? If we start with Glyn Berry.
Good morning. My name is Glyn Berry. I'm a palliative care social worker and a lead allied health professional, and I'm co-chair for the Association of Palliative Care Social Workers.
Thank you. And I'm Professor Nicola Ranger, and I'm Chief Exec and General Secretary of the Royal College of Nursing, but previously was a chief nurse in acute hospitals for 10 years.
Rebecca Paul.
Thank you, Chair. This is a question to Glyn Berry, please. In your statement published in November 2024, you say there is a risk that without a more sustainable model of funding for palliative care, many people will choose an assisted death as the only way to escape from unbearable suffering. Can you just elaborate on why you say that, please?
Yes. As experienced social workers working within the realms of a society that quite often is split into have and not have, we already see the despair and difficulties that people encounter with inequitable care to palliative care services. We know that that a lot of services are delivered by charities, as well as statutory agencies, the trusts, and we know that the funding around palliative and end-of-life care currently is a real issue and has been heading that way for some years. In our experience professionally, and what we would hate to see that's been happening in other countries where assisted dying is already in place, is that people feel that they don't have an option other than to apply for assisted dying because they don't know what else may be out there for them, and that is the role of a social worker when we work with our patients. We look at the bigger picture, not just what's happening clinically. Obviously, we depend hugely on our clinical colleagues and expertise, but our specialism, if you like, is to look at what else is out there for a patient and their family and friends as well, because there is a part of the patient's journey as the patient themselves. But we also know that palliative and end-of-life care is hit and miss in terms of what people can access. The Marie Curie report in 2024 showed that there are massive disparities in terms of better care for people at end of life or with a palliative condition. And it has a significant effect on people. What we say to people is we would help people to live as long as they can, as well as they can in palliative and end-of-life care situations. But that's really difficult when the resources aren't there to be able to do that, and things become a huge priority.
Thank you. And I mean, what would a more sustainable model of funding for palliative care look like?
slightly going off topic. If we can have a brief answer, because that's slightly going off topic.
Sorry. It would be something that was equitable for everybody, and right at this moment in time, it isn't. As I said at the beginning, some people get it and some people don't, and a sustainable model would be around fair access to everybody.
Thank you.
Tom Gordon.
Thank you, Chair. Obviously, the bill in its current form looks quite heavily at medical professionals. We've already heard from lots of experts in that area. I think, obviously, one of the things that social care and palliative care often deal with are those really hard, difficult conversations. What lessons and advice do you think you might be able to give, and how might you be able to feed into an input in this process?
Thank you. So, we work very closely with clinicians and other health professionals, and we talk about a multidisciplinary approach, because a person isn't just a two-dimensional person. There's everything about their life needs the input of other people in these situations. In terms of a social worker, our expertise and strength, if you like, is being able to ask difficult questions, being able to really dig into people's thoughts and feelings and opinions, giving them an opportunity to sometimes say things that they've never said in a whole lifetime. Our other areas are around capacity, assessing capacity, and giving people the options of knowing that there isn't just one way of doing things. As an example, I work in a hospice setting and have done for the last 6 or 7 years, and I see daily how social workers contribute to the wider MDT in terms of safeguarding, in terms of capacity, in terms of applications for deprivation of liberties. But we also do that psychosocial aspect of palliative and end-of-life care. We sit and talk with patients, we advance care plan, we deal with some of the practical aspects of supporting to arrange funerals. For families where a parent or a primary caregiver is the person who is ill, we will work with external agencies, statutory agencies such as local authorities, to support where there may be children or vulnerable adults who are being cared for by the patient, to have provisions put in place for after the death of the person. And we also support with pre and post bereavement support of both with the patient and family, and with the family post bereavement. So we have quite an extensive skills catalogue to support patients and families. But I think one of the biggest aspects and skills that we have is that communication, and not being afraid to go where perhaps other professionals may feel uncomfortable going. Having conversations about people wishing to end their life, that is not, it's not actually a new thing. We have those conversations quite regularly. Sorry.
Yeah, no, that's fine. Thank you very much. That's really, really helpful. And I'm just wondering, in terms of then, for people like yourself and organisations like yours, what do you see your role in the assisted dying process as being? And do you think it might be better if you were further involved?
So in our association, we have a list of recommendations, and we're very conscious that the bill itself is very heavy from a clinical perspective, and there are a number of things. We don't feel that the decision and assessment should be primarily all on the shoulders of a health professional, the clinician. Some clinicians are fantastic with assessing capacity and being aware of the safeguarding aspects of situations, but not all are. We feel that our expertise lays in that particular area, but also as part of, so when we look at the overview of the process set out in the bill, it is very, very clinical, and there isn't anywhere, just looking at the overview, where it talks about the clinician exploring the other aspects of a person's life. Is very much around the clinical aspect, quite rightly, because these are experienced clinicians. So we feel that we should be involved in these decisions from the capacity and safeguarding aspect, but also looking to see whether the things that we can do to help that person make a more informed choice. Because if their decision to take their life is based on the fact they haven't got secure housing, their benefits or finances are all over the place, they don't want to be a burden on their friends or families, or indeed have nobody at all. Those are areas that are very, very familiar to us and what we do on a daily practice, and therefore we feel that we are well placed to be in that position of supporting the clinicians in the whole process.
Yeah, no, thank you very much. I think that was a really comprehensive answer, and I think the sort of key point you touched on there is that multidisciplinary approach. So, I mean, fantastic. Thank you very much.
Juliet Campbell.
Thank you very much to both of you here today. During this whole discussion, for many, many months, there's been a lot of talk around palliative care and pain management, and which can lead patients to come to a decision or to consider assisted dying as an option. If a doctor, so my question is, if a doctor has suggested to a patient that assisted dying is an option, or a patient has said that they are considering assisted dying, do you think that they should be referred to another clinician, or do you think there should be an independent organisation that is a non-clinical setting where a patient can go to have further discussions before taking that route onto assisted dying?
I think there's something...
It's to the professor.
Yeah, thank you. I think there's something really important about a big difference in the beginning with regard to palliative care and assisted dying, with regard to pain control, pain management. It's absolutely essential those two things are slightly separated, because it would be heartbreaking to think that someone would, that would be the primary reason that someone would want to assist in having their in dying because of pain management, because we should be able to control and support someone's symptoms and pain. The primary thing, I think, as you said, with regard to being referred to another organisation, is around autonomy. And I absolutely agree with what was said earlier. You would want anyone that is considering assisted dying to be slightly separated out of their normal clinical pathway, so not part of mainstream care for someone in a hospital or in an organisation. So there's something really important about separating that out, both in the discussions around this decision making and any care involved in assisting them to die. So I think those two things do need to be separated.
So rather than going straight to the route of I've made this request or this has been suggested to me, right, this is the path that we're going down, there's something that should happen in between.
Well, you wouldn't really want any clinician to sort of push this view on any patient. It has to come from the person themselves, and that's the key thing around capacity and autonomy. I don't think it should be something that people ever say to a patient or an individual, is this something you've considered? It has to be led by the patient.
Thank you. Thank you.
Dr. Murray.
Thank you. So for Professor Ranger, please, just picking up on some of the points that Glyn Mary made in relation to the different circumstances that certain patients find themselves in. We know barriers to healthcare as a result of health inequalities, access to education and disability are well documented. How could your members help remove barriers to such groups in accessing the provision of assisted dying?
It is absolutely vital that any of those barriers are removed, and that we always maintain, outstanding care at the end of someone's life. And in reality, majority of palliative care is given by nursing staff, whether it's in the community, someone's home, or hospice, or a hospital. So the majority of palliative care is given by nursing staff. And it's absolutely key that, as it is an expertise, it is specialist practice, it is something that someone is both extra training, extra education, and really have those skills around listening to patients, advocating for them, and ensuring that they are pain-free at the end of their life. So I would say that those skills now are something that nurses have, and it's absolutely vital that our nursing members continue to maintain that. And they are often the person that a patient or a person will speak to at 3 a.m. when there's no one there. And I think it's absolutely vital, as Glyn said, that wider team is absolutely included in this bill. And we know the bill talks about it, the guidance and the recommendations being for the Chief Medical Officer. But when the majority of care is given by nursing staff, I think it's absolutely vital that the Chief Nursing Officer is a key part of the guidance and the drawing up of any care going forward, because that is who will give, even in these circumstances, the majority of the care.
And just to pick up on your important point about advocacy, if coercion, undue pressure or dishonesty by family members or other supporting parties that the patient was relying on in relation to that patient seeking assisted dying, how would your members detect that there may well be that coercion, dishonesty or pressure from such individuals, and at what point would a report to the police take place by your members?
Safeguarding is part of our professional responsibility now. So that is part of your role, actually, whether it's a child, adult or an elderly person, to be vigilant around all of those things: financial, misconduct, physical abuse, mental health abuse. Any of those things is a responsibility of every nurse now, actually, and it's a very good and simple process. You do not have to investigate or give a judgment. You need to refer for it to be investigated, and that takes the pressure off an individual clinician. Our job is to be vigilant and to refer safeguarding anywhere where we think there is of any form of abuse. And I think that process would still remain and could be part of how we do things now.
And just to follow up on that, because it's really important, so you think that your members would have the ability to pick up on such coercion, dishonesty and pressure from other parties potentially being placed upon a patient who is seeking assisted dying, and what other training or support would be needed for your members?
We would want more support, so I'm not going to say that we don't always get it right, because sometimes things happen and we miss them or we don't report. So I can't say we get it right 100% of the time. But when it talks about education and training for medical staff within the assisted dying bill, it's absolutely vital that nursing staff are included in that, because we will need to be very vigilant around anyone feeling that they're a burden. I think that this bill would add other skills that we would want to make sure that nurses were included in. That education for medical staff is absolutely pertinent for nursing staff, so they build on skills they already have, because there will be a difference between the care of someone wanting assisted dying and palliative care. They are two slightly different skills, and I think it's really important that those are always not lumped together. And actually, if you are involved in assisted dying, that is a specialist skill that will require specialist training, and we would very, very much want nursing to be included within that.
But you would believe that your members would be able to pick up on and identify issues like coercion?
I do. Yeah, they're professionals, and I believe they would.
Thank you.
Thank you, Chair. My question's for Glyn Berry, if that's okay, and it's just diving a little bit along some of the points that were made earlier. I think your organisation has recommended the new role of an approved palliative care professional, and just kind of as they kind of get into detail a little bit more, you make a number of recommendations of what that role would include. For example, ensuring that a person has a mental capacity to make the decision. Are you saying, therefore, that you believe this new role should sit alongside the two doctor processes as sort of already outlined in terms of that kind of final decision making, i.e. if they felt, for example, that the person didn't have the mental capacity, this approved palliative care professional would have the ability to stop the process, as it were. And secondly, what sort of level of training would that person need in terms of time? So, i.e. we've been talking about a 2-year process, so if this new role was to come into effect, how long would this person need to be trained for to be able to adequately fulfil the role? And do you have a sense of how many of these professionals we would need in order to kind of make this a functioning system as well? Sorry, 3 kind of separate questions within that. Directed to Glyn Berry, sorry.
Sorry, so to answer the first question, we do feel that the role of an approved palliative care professional would sit beside the clinicians for reasons that I outlined earlier, to have that balance, I guess, of clinical and social observations and assessment. In terms of the training, as social workers we already have the continuous training opportunities of becoming best interest assessors and practice educators, approved mental health practitioners. So we envisage that the training would very much be along those lines. To currently do the roles that I've just mentioned does require a course of training currently at university, and in terms of numbers, our thoughts are that at this moment in time it would be around palliative care social workers, whether they were in charities or trusts, local authorities or independent, because that is where things sit with us at the moment. We know our roles, but we like to think that would roll out in terms of other professionals, because in terms of assessing capacity, it isn't specifically the role of a social worker. Other professionals are able and do complete capacity assessments. In terms of numbers, that's quite difficult to answer at the moment, but if we were talking specifically around palliative care social workers, at this moment in time we have around 200 members in our association, but there will be other people out there that are maybe, are not members and we don't know who they are. But it's a role that could expand. And one of the other things that we made in terms of a recommendation is that palliative and end-of-life care, which is an aside to your questions, is that palliative and end-of-life care is also brought into qualifying roles for people in training, such as doctors, nurses, allied health professionals, as well as social workers, and it's something that we could see could go in the future.
Thank you, Chair. Thank you for coming and giving evidence today, and thank you for meeting with me recently. You represent organisations that have both got a neutral position on assisted dying. I'm really interested in what you're talking about in terms of this multidisciplinary approach, and I think it's a really valuable conversation, so thank you for raising those points. I want to ask a bit more about what this end-of-life conversation looks like in your experience, because you're absolutely right, from all the people that are spending time with patients in their last few months of life, it's often nurses, it's often palliative care social workers, so I think you've got a really important role to play. But I'm also interested in terms of what this would actually look like in reality. And there's been sort of talk of kind of a separation of palliative care and assisted dying, but actually I think what we should be looking to do is embrace a holistic approach to end-of-life conversations and end-of-life care, which is indeed what's happened in other jurisdictions. So you'll have a patient who might actually sign up for assisted dying but never does it because they have good palliative care and they work with their palliative care experts and specialists. So I think it's important that we don't try and separate these things. And actually one of the strengths, if you might give me your views on this, is that having these conversations about death, about dying, about end of life is a really positive thing. But I think your members have got a really important role to play in this. So could you talk a little bit about, maybe for you, Professor Ranger first, that holistic approach that your members take?
You're right in regard to the conversations and the care around dying and having those conversations with people around pain, around pain management, symptom management. That is the role particularly of palliative care nurses. But when the assisted dying, I think sometimes the conversation is slightly different actually. So just talking more as a nurse here in some ways, because the primary reason that assisted dying is often a discussion is a lack of autonomy, not pain. Yeah. So the conversation tends to go genuinely in a slightly different way. Symptom control, being scared of pain, understandable, and we absolutely have the ability to be able to have that right for people. But actually, when it comes to seeking assisted dying, the primary reason is usually autonomy rather than pain and fear of dying. So in a practical way, I think an experienced nurse, an experienced doctor will start to gauge the difference in those conversations because they are different. And I think it's being really clear around those conversations and really listening to what people have to say and then having a way to be able to ensure that what an individual wants is something that you listen to. And I absolutely agree, Glyn, around safeguards, around all of those things that we need to absolutely make sure are there. But the whole point of assisted dying is to not to be paternalistic, but to respect autonomy. And whatever safeguards we ever put in with that, we've got to be really careful not to ignore that right of autonomy, which is primarily what this bill is trying to preserve. So I think it's about being really vigilant, really listening, but a primary role of a nurse is to advocate. Yeah. Not your personal view, but to really listen to somebody else and to ensure what they want is pursued. And I think in all of that discussion, it's really important that doesn't get lost.
That's incredibly helpful, thank you. And you're absolutely right to bring it back to that patient autonomy, that patient choice, while putting all the safeguards in place so that we're very clear it is their genuine choice, and it is a choice based on what they really want to do. And it sounds as though you're saying that your professionals are trained to have those conversations, which is very reassuring. Yeah, brilliant, thank you. And Glyn, do you want to add anything?
Just to say that Professor Ranger, I absolutely agree. My experience of working with palliative nurses and nurses in general is long, historically, and I have exceptionally positive experiences and continue to do so. And I think we learn from each other. And I think what's really important is that we can have those conversations with the person and ask questions that they might never have been asked before, such as, what is it that you want? And I think, again, Professor Ranger is absolutely right in terms of the autonomy and a person having control. It's because once that diagnosis is given, it can be a downward spiral for a person, and they feel that they lose control, and patients talk about this and families talk about it. They have no control over what's happening, and to effect that is true in terms of what is happening from a disease, an illness trajectory, but actually it's so important to remind a person that they are still the person that they were before that diagnosis, and they will continue to be that person, and that they still have a voice. And I think both of our roles professionally and alongside other clinicians, that is what we seek to do all the time. in our work, and that is why an MDT approach is so important. And ultimately, if we find that once you've asked all the appropriate questions and you've put potential safeguardings in place following conversations, a person may not choose at that particular point to end their life, as you'd mentioned, Kim, a few moments ago, and may actually continue to live to the end of their natural life.
So, John,
Thank you, Chair. When the RCN's Scottish director gave evidence to the Scottish Parliament during the discussion around Scottish assisted dying for terminal adults bill, he expressed the RCN's concern that there were not sufficient safeguards in place to protect nurses and nursing practice around assisted dying in Scotland. Are you satisfied that the bill we have before us in England and Wales address those concerns, or would you like to see amendments to ensure that the mental health and well-being of nurses involved in the process are protected should this bill become law?
Yes, I think we would want to see more support and protection for nurses. Of course, in Scottish legislation or Scottish exploring of assisted dying, the second clinical decision maker is a nurse in Scotland. So it's a doctor and a nurse, whereas in England and Wales we're looking at obviously two medical qualified practitioners. So we absolutely do want to make sure that the skills and the support is there for nursing staff, and also as the ability, as I heard was saying with our medical colleagues, the ability to not be involved in assisted dying absolutely has to be supported. So it can't be an expectation of the role. It has to be something that you choose to proactively take part in as a conscious decision. It cannot be something that's ever just an expectation of a nurse, and we're absolutely adamant about that. And we do think that this bill cannot just support the needs of medical staff. Nursing absolutely has to be included within that, both in skills and also support.
Well, thank you. Professor, I just wanted to test a little further on this notion of a separate organisation that you mentioned earlier, because I can understand a sort of separate discipline emerging, acquired by training, which obviously is what happens in palliative care at the moment. But we heard from previous witnesses that simplicity in terms of safeguards was key, and also in particular from the CMO that we had to avoid the last 6 months of someone's life being a bureaucratic kind of nightmare. And given that you, at the moment, within palliative care and palliative nursing generally, you're already dealing with patients who are electing to refuse treatment, to refuse food and water, or indeed to support patients following an advance directive. If you're supporting people in those circumstances as they move towards their death, do you think that it could be absorbed within the current functions rather than having a separate organisation?
It's difficult. I mean, and if I'm honest, we haven't probably explored that enough as a college within our thinking. But I think there's something about what we know what we wouldn't want to see, whereas an expectation that it becomes part of a pathway. It's got to be something you actively seek and opt into. So how that is completely administered, I think, if I'm honest, I think it probably requires more thought. But what I wouldn't want to see is it becomes an expectation of a pathway, because then I think the pressure on the individual may change, and that's a safeguard that I think we need to guard against. But I am worried that you don't want to make it so bureaucratic for the individual that it becomes just absolutely impossible to actually have your autonomy respected. So I think how that happens is going to be something that needs further exploration. So I think we would fully support making it as clear and as unbureaucratic for the person as humanly possible, but not see it almost as a sort of pathway within our current setting, because I think there could be that sense of this is something that has external influence rather than being someone that someone actively seeks for their autonomy.
Thank you.
Thanks very much. You've done this very powerful report, The Last Shift, which talked about the moral injuries, a very powerful phrase, felt by nurses in light of the shortages in care, in the NHS and in social care. Can I ask you what a nurse or indeed any health professional should do in circumstances where a patient is requesting assisted dying and qualifies for it, when that professional thinks that what they really need is care, palliative care, but it's not available because of the shortages in the palliative care system? What should they do in those circumstances?
It is difficult, but I think from my experience there are ways to try and get people palliative care, whether that is, as we said earlier, whether it's via other organisations outside the NHS, within hospice care. So I think there are ways through the current routes to get people the care that they need.
Sorry, just to be clear, you think it's possible for every patient who needs it to get the palliative care they should have?
I don't think it's as good as it needs to be. We know that it's hard sometimes for people to access the care. We know the struggles on hospices. We know far too many people die in hospital. So we know there are real challenges on social care and health service. So I can't say it's not without challenge.
So it could be possible that somebody's requesting assisted dying because of the absence of adequate palliative care.
I think when you put it in a question like that, it could be possible.
Okay.
But what we would want to strive to do is have a system that doesn't leave anyone in distress.
Well, indeed. And lastly, very interested in your suggestions about a separate service and about the importance of protecting the rights of professionals who don't want to be involved. Do you think, Jenny, I can't decide for myself what the answer is. Do you think it should be possible for a care home director? I was very conscious of the plight of care home workers in the pandemic, and I regretted my vote to mandate the vaccine to them. People working in care homes, do you think it should be possible in the bill for the director of a care home to exempt their whole service, that care home, from being involved in assisted dying? This is where people live, after all. And if somebody's having it there, it could affect the entire, well, certainly the atmosphere of the place, but also the work that all of the people working there have to do. Do you think they should be protected as an organisation?
I think particularly for nursing homes, I think that would be difficult, and I think that's something as to how and where people end their life probably needs further thought and further explanation. And I think there's something about being really clear. If you're the leader of that nursing home, we would have to explore your ability to be able to advocate as the care you want to be able to give in that nursing home. So I think all of these quite practical things need really further exploration. But it is difficult, because for someone that maybe wanted to end their life, if that's their home, they may want to be there. So I think it's all of these practical things that probably need further thought and exploration, because I think it could be argued either way.
Okay, well, we've got about 40 seconds left, so I don't think we will get in another question, but I just wanted to ask Glyn, in the final 30 seconds there, is there anything you wanted to add to any of the points you've heard?
I don't think so, but I think that was a really good question, the last question around care homes, and I'm just already thinking about implications for registrations of the CQC and what that would mean in terms of the process and the protection of staff and residents and families. I think that's a really helpful question to think about. Thank you.
Order. That brings us to the end of this allocated time for the committee to ask any questions. I want to thank our witnesses on behalf of the committee. Glyn Berry there, co-chair of the Association of Palliative Care Social Workers, who was on Zoom, and Professor Nicola Ranger, Chief Executive and General Secretary of the Royal College of Nursing. Thank you all very much indeed.
public and the proceedings are being broadcast. Before we begin, a reminder to members to please switch electronic devices to silent. We will now hear oral evidence from Dr. Rachel Clark, who is palliative care doctor, Dr. Sam Ahmedazi, who is Emeritus Professor in the Medical School at the University of Sheffield, James Sanderson, who is Chief Executive at Sue Ryder, and Dr. Sarah Cox, who is the President of the Association for Palliative Medicine. For this session, we have until 3:15 p.m. And could witnesses please introduce themselves for the record, please? Starting on the left.
I'm Dr. Rachel Clark. I'm a hospital palliative care doctor with a decade practicing in a whole range of settings, the community, hospices, small district general hospitals and a large teaching hospital. I'm also a former journalist and current author who has written 4 best-selling books for the public about medicine in the UK. I campaign very actively for greater awareness amongst the public around the topic of death and dying. And I have extensive experience teaching communication skills to medical students, junior doctors, nurses and other members of the MDT. My personal view on assisted dying is I'm not opposed in principle, but I have significant concerns around the issues of consent and capacity.
Good afternoon. My name is James Sanderson. I'm the Chief Executive of Sue Ryder, a leading palliative and end-of-life care organisation who also support people living with grief and bereavement. I've recently joined Sue Ryder. I've been there for 6 months. I was previously in NHS England as Director of Community Health Services, Personalised Care and Palliative and End-of-Life Care. I'm the former Chief Executive of the Independent Living Fund. Sue Ryder as an organisation have adopted a neutral position in regard to the assisted dying bill, and I'm here today to provide information regarding the provision of palliative and end-of-life care and some of our concerns in relation to how the system is currently operating across the country. Thank you.
I'm Sarah Cox. I'm a consultant in palliative medicine. I've been in palliative care for over 30 years. I'm also the president of the Association for Palliative Medicine of Great Britain and Ireland. It's a member organisation with over 1,400 members. There are naturally different views amongst our membership, but in polls over the last 10 years, the results show that about 80% of our members are opposed to legalisation of assisted dying, about 5% in favour. And the reason for the opposition are many, but some of them include the inadequate current provision of palliative care, which doesn't offer patients a choice, concerns about how the safeguards would be enacted in this bill, and concerns about the impact of assisted dying on palliative care resources, funding, and on the workforce.
Thank you. Thank you very much for inviting me here today. My name is Sam Ahmedazi. I'm a retired professor emeritus of palliative medicine from the University of Sheffield. I have, not boasting, Sarah, but 39 years of experience in the specialty. I was one of the people involved in setting up the new specialty of palliative medicine back in the 1980s. My experience is of working in a hospice for 9 years and then 20 years as a consultant and professor at the University of Sheffield. I'm a clinical academic, so I take very much an evidence-based view of healthcare, and palliative care is just another kind of healthcare. For instance, I chaired the NICE guidance on the last days of life. I was clinical advisor to the NICE guidance NG 142 on service delivery in the last year of life as well. So I come from that background. My experience around has been around the world, visiting academically, lecturing, working. I was visiting Spinoza professor at the University of Amsterdam for 10 years, where I lectured people who were actually delivering euthanasia in Amsterdam about what they could do in terms of palliative medicine as well. So that's where I'm coming from. I'm a supporter of the changing the law, and I commend this bill. I think it's one of the safest I've seen in the world.
Thank you. If members could indicate if they wish to ask a question, and we'll take names down, and then if you indicate who you want to ask the question to, if that's okay. Nice shot.
Thank you. Thank you, Chair. Thank you very much for those introductions. Mr. Sanderson, I've got a few questions for each one of the panel. In the first instance, Mr. Sanderson, do you think palliative care in this country is fit for purpose?
Thank you very much for the question. So I think there are clearly gaps in the provision of palliative care. However, starting with a positive, I think the provision of palliative care that we have in this country is exceptional. And I think we are actually leaders in many ways across the world in the way in which we support people who are facing those challenges in their lives. However, our findings in relation to palliative care show that whilst about 90% of the population could benefit from palliative care, only 50% of people currently able to access it. And one of our concerns is that the provision of palliative care across the country is quite patchy at the moment. I don't think there's been a thorough assessment of the level of palliative care in place. And not just the provision of palliative care specifically, but how other services, such as district nursing services, for example, interact with palliative care. Because in some areas, the provision of district nursing services for general care and support for people who may be at their end of life is very strong, and in other areas it is not so strong. So at Sue Ryder, one of the things that we are really concerned about, and our survey showed us that 77% of people said that they were concerned about the lack of availability of palliative care, and enabling more people to consider an assisted death than otherwise would. And actually that concern went up to 84% for those who were in favour of assisted dying. So I think that's one of the things that we really need to look at, is the provision of palliative care and the specifics in the Act that make reference to the fact that people should be offered what is available to them. I think we need to have a much clearer definition of what available actually means.
Thank you very much. Dr. Amazai, I understand from your evidence you've submitted, you've said you studied the reports from and spoken with medical and nursing clinicians from the US and the Australian jurisdictions, and I'm satisfied that external coercion has never been reported or led to a prosecution. The state of Oregon carried out a survey of people who died under its assisted dying scheme. In 2023, the state of Oregon itself said in its report, assisted dying, that 43% of those who died said they did so because they felt they were, and I quote directly from the term used in the survey, a burden on family, friends and caregivers. Is that something you're prepared to see happen in the UK?
Thank you. If I can start with saying that it's absolutely come to the core of being British that we're always saying sorry, aren't we? We apologise for everything. Everything we do, treading on toes, think we might do, we're always worried about being an imposition. And all my professional life, I've come across patients and families in which there clearly is that feeling going on, usually with an older person or even a younger person who's drawing a lot on the emotional, physical resources of the family. That it's natural that we feel a burden. It's impossible to take that out of the human nature. The issue is, does that feeling that one is or might become a burden something that could influence a decision as major as looking for assisted dying? In that respect, I look to all those jurisdictions where they have been offering assisted dying in different ways, and I have never seen a single case ever taken to the police or prosecuted, and evidence I've heard from other jurisdictions show that yes, it's possible, because we all go through life feeling that we're a burden on someone, but it does not influence people in this particular decision. If anything, I'm told that in other jurisdictions, families are saying, no, don't do it. They're exerting, negative coercion, don't do it coercion. But people are saying, no, it's my life, I've made my mind up. They have mental capacity, and we respect that.
Thank you.
Thank you. Sean Woodcock.
Thank you. We had lots of, coercion is one of the main issues that people who are concerned about the bill raise as why they are in opposition to it, that would include myself. We had many distinguished witnesses this morning, and the view was that, to quote, coercion is rare in healthcare generally, but also it's rare, and that staff are so well trained, have safeguarding training, etc., have such a level of experience that it was almost given across that we didn't really need to worry about it. I would put to the panel your views on that. Is it really something that those of us who are concerned about coercion, is it really something that we should not be so concerned about? Yeah, that'd be great.
Well, I would, and this is based on my clinical experience, I would strongly push back on that in the strongest terms. I'm the kind of doctor who believes there is nothing to be gained by sugarcoating reality. We have to be absolutely honest with patients, with the public, about shortcomings, failings, areas where my profession, the rest of the NHS are getting things wrong. And it is my clinical experience that not only are the majority of doctors not necessarily trained in spotting coercion explicitly, they're often not trained explicitly in having so-called advanced care planning conversations with patients around the topic of death and dying and how a patient would like the end of their life to proceed. It is almost impossible for me to overstate how much avoidable suffering occurs right now in the NHS, not because of lack of resources for palliative care, although that's an enormous problem, but because of lack of confidence and skill and expertise amongst the medical profession writ large with these very difficult conversations. We're all familiar with the idea of death and dying being a taboo in society. People are scared of it. They hesitate about bringing it up with their friends, family. Well, in my experience, medical students and doctors, many of them also suffer from that anxiety. They are scared. They find it a taboo subject. And what that means is sometimes coercion occurs because literally the doctor, the consultant responsible for this patient's care, won't even bring up the fact that they think the patient is dying because it's an uncomfortable conversation. Conversely, I have worked with senior hospital consultants in the NHS who have deliberately prevented our team from accessing their patients because they believe the hospital palliative care team wants to kill the patients. And if I go and see the patient, I will give them a lethal dose of drugs. So these are the kinds of extraordinary misunderstandings and failures to prioritise patient autonomy that are happening now. And that's even before we get started on conversations around whether or not someone would like to consider assisted dying. So it's a huge problem.
Thank you.
Thank you. My question is for Dr. Ahmedzai. The Select Committee report on assisted dying received evidence that there were not any indications of palliative and end-of-life care deteriorating in quality or provision following the introduction of assisted dying. Indeed, that introduction has been linked with an improvement in palliative care in several jurisdictions. So, two questions, if I may. What more could the bill do to strengthen the available choice at the end of life and the regulation of these choices as set out in the codes of practice? If you don't mind answering that first, and then I'll come back to my second question.
Thanks very much. Yes, I visited many of the jurisdictions around the world, from Oregon, where I met the original judge who brought in the law, and the doctors, the nurses, and patients who were having it. And it was clear to me that if patients had not, for instance, accessed palliative care, they were pointed towards palliative care. Obviously, you can't force anybody to go and have palliative care, but they're certainly informed about it. In the Netherlands, what I would commend is a system called SEND doctors, support and consultation in euthanasia. Forget that last word, but these are trained doctors who are working for the equivalent of the BMA, I believe, who are going and actually supporting doctors, as Dr. Clark has referred, who are not familiar with things. They often come from a background of palliative care, pain medicine, so they're making options available that, for instance, other doctors in the process have not brought up. In Australia, again, there is this clear evidence that palliative care is becoming more available. The European Association of Palliative Care produced a report more than 10 years ago, and they examined all the countries in Europe at that time and found that there was evidence that palliative care was improving in scope and availability alongside the forms of assisted dying that were happening there. So I am reassured that actually bringing in some form of assisted dying, particularly the form that's proposed here, would be a boost to palliative care, because one of the things I would like to see is that anybody that's involved in the process is constantly asking the patient, what about palliative care? You know, have you actually accessed it? Right now, if they haven't raised their hand and asked for assisted dying, no one has that conversation with them. They are in a vacuum, in a bubble, not receiving palliative care, whereas this would actually make it possibly more available.
Thank you. I've got 2 follow-up questions on that basis, very briefly.
We've got till 1:45 to do this, so I'm going to be as lenient as I can, so to speak, in terms of questioning, but just bear in mind that and also the panel. I don't want to squash any discussion, but just bear that in mind. We've got till 3:15 to take evidence.
Okay, thank you. On the basis of your 39 years of experience then and the select committee evidence I mentioned earlier, do you acknowledge that improvements on both assisted dying and palliative care can run in parallel and do not need to be mutually exclusive?
In the interest of brevity, yes.
Thank you. And then just to follow up, and it's an important one because you talked about the role of medical practitioners discussing this issue, which is of course in clause 4.2 of the bill currently. Your own evidence, paragraph 4.2, was very helpful in discussing this and makes it clear that it's entirely consistent with current medical practice and with compassionate care to raise assisted dying. And that raising that topic does not have adverse effects. How could Clause 4 be strengthened to make sure patients are presented with the range of treatment options at the end of life and relay any concerns others have raised about suggestibility where this is mentioned in isolation?
Thank you. Complicated question. I mean, the first point is that right now, as Dr. Clark has pointed out, it's scary to patients to be told that they may actually be receiving palliative care. Many patients, when it's been mentioned, say by an oncologist, oh, I don't want that, don't let them come anywhere near me or anywhere near my relatives. So it's not unusual that people may actually have an adverse reaction just to hearing about a service, but here the difference is that the person's actually asked for it. I personally believe that it would be advantageous if there was formal training, as Dr. Clark has mentioned, specifically to have the kind of conversations that we now talk about, you know, psychological issues, suicidal tendencies. I mean, it used to be thought that if you mention suicide to somebody, it's going to give them the idea. Of course it doesn't. It saves them because they say, yeah, I was having those thoughts. So bringing up assisted dying is never going to be harmful to the person, even if they hadn't thought of it. They will just say, well, it's not for me.
That's very helpful, thank you.
Thank you. Rebecca Paul.
Thank you, Chair. My question is to Dr. Sarah Cox. Can I ask what you think the impact of the introduction of assisted dying would be on palliative care?
Yes, thank you. So Professor Amazai has talked about the evidence which was written up to 10 years ago. There's actually some more recent evidence looking at the last 10 years where countries in Europe and in America, states in America, have been assessed in terms of the development of palliative care services. And what that more recent evidence shows is that although palliative care services have improved in those countries where assisted dying has been implemented, they have improved three times better in countries where assisted dying has not been implemented. So the evidence from that study shows that actually the implementation of assisted dying is impeding the development of palliative care services. I think the other thing that we're really concerned about is the impact on funding. So if it's unclear how this is going to be funded. It looks as if it's going to be within healthcare, and if it's within healthcare, then inevitably there will be competition with other aspects of healthcare, including palliative care, for those limited resources. There are finite numbers of doctors, of nurses, of side rooms in hospitals. If this is funded with palliative care and assisted dying being the same pot, then I think there will be a massive detrimental effect on palliative care, because again, we will be in competition for a limited resource. I think the other thing that concerns me is about our palliative care workforce. We know the palliative care workforce is already in crisis. Our members told the Royal College of Physicians in 2023 that 83% of them had staffing gaps, and more than 50% of them were unable to take their leave because of those staffing gaps. 43% of them said that if assisted dying was implemented within their organisation, they would have to leave. So this has a massive impact on how palliative care, both in terms of the potential for palliative care to develop, in terms of funding, and in terms of our workforce, who are really concerned about this.
Thank you. And in terms of the data that shows that palliative care hasn't improved as quickly in the locations that offer assisted dying, can you offer us any further insights onto why that may be, and what should we be thinking about as a committee in terms of the bill in order to safeguard against that happening? Because I think we all agree here that we do not want to see palliative care decline.
So I think the first thing to say is palliative care is inadequate currently, and not only do we need to not see it decline, we need to massively improve palliative care in order that this bill is actually offering patients a real choice. We know that effective palliative care can change somebody's point of view from having a terminal illness and wanting to die to having a terminal illness and wanting to live. And we also know that 25% of the people that die in this country do not have the palliative care they need. That's more than 100,000 people a year. Now, if we're denying them the palliative care they need, which might make their lives better and reduce their suffering and change their perspective about whether they would want assisted dying or not, for me, that's the priority in terms of how we reduce suffering in this group. Insights of how we prevent this happening, I don't know. I think what I've said about not having the funding together with palliative care is really important, because I think assisted dying and palliative care need to be separated in terms of how they're delivered and the funding.
Thank you so much.
Sarah Green.
Thank you, Chair. Clark, if I may. Can I ask, what are the existing statutory guidelines around end-of-life practice, and how are those decisions logged, recorded and monitored?
So the fundamental principle is always that the default is the patient has capacity unless it's very clearly the case otherwise, that there is evidence they do not. So we presume patients have capacity. We always, as doctors, are obliged to ensure that when deciding between different treatments, patients have informed consent. So that means we need to lay out the whole array of treatment options, the risks and benefits of them all, to empower an individual patient into making decisions for themselves. And regarding the issue that's been alluded to of whether or not doctors should in fact be prohibited from raising the issue of assisted dying, it's my belief that that would actually fundamentally alter the doctor-patient relationship, because if consent is not informed, and it isn't informed if we're not laying out all the different options to a patient, then we are denying patients the opportunity to make decisions for themselves. We currently are able, a patient is always able to refuse every treatment, every life-prolonging treatment in particular, that they choose to, provided they have capacity. We as a doctor may think that a decision is unwise, and that's irrelevant, because those days of bad old paternalistic medicine are gone. The patient makes the choice. So if a patient says, I don't want chemotherapy, I don't want to eat, I don't want anything at all, no treatment, we respect that unless they lack capacity. The elephant in the room with all of this is the capacity assessments, and anybody, I would suggest, who pretends that those assessments are easy and routinely done well in the NHS has not got enough experience of observing that happening. I teach capacity assessments to doctors, medical students. It is often the case that they are very poorly conducted. The doctor doesn't understand the criteria for assessing capacity, and that's even if it happens at all. So sometimes a paternalistic doctor will decide that a patient is dying and we should stop their antibiotics because they're clearly now at the end of their life. They have a chat with the family who say, yes, we agree, and nobody talks to 82-year-old Mrs. Smith and asks her what she feels about it, because they assume she doesn't have capacity because she's old, for example. I see that regularly, and sometimes a palliative care team will intervene in those situations because the professional and legal framework that is meant to guide this practice is just not happening. So it's a very, very fraught and tricky area, and if there was one thing that I would say to the committee regarding making this bill as robust and strong and safe as possible, it's please to consider seriously the matter of education and training from day one of medical school onwards. Death is at the periphery of a medical school curriculum. Death and dying is not taught. You might get a week of palliative care in 5 years, and that has knock-on effects all the way through at every level of seniority in the medical workforce.
I just have a follow-up question, if I may. It's around the bill introduces a monitoring and review process, including an annual report by the Chief Medical Officer, and I just wondered if you had any reflections on whether that needs strengthening.
Yes, I think in the spirit of transparency and making this as safe as possible, it needs to be significantly strengthened, and I would suggest there need to be more safeguards in place. For example, if anyone in a hospital, whether it's staff or patient or family member, have concerns around a particular case, then there should be mechanisms for those to be raised in a proactive way, just as we have guardians of safe working and freedom to speak up guardians in hospitals. At the moment, those opportunities to assess and appraise the safety in real time once a bill is in place, I just don't think they're robust enough at all, and the more we can have of that, the more that will allay people's fears, I'd suggest.
Thank you, Chair.
Daniel Francis.
Thanks, Chair. My question is to Dr. Medzai. So in the paper you produced, you've talked about specific recommendations regarding training experience of the doctors involved in the process. You've suggested 5 years, for instance, and some other experience. So have you got examples elsewhere in the world where such a scheme's been implemented, and do you believe in the United Kingdom we've got enough trained doctors who've got that level of experience and would therefore be partaking in this part of the process?
Thank you. put me on the hop there because I can't quote you the actual level of training that doctors have received elsewhere, except that examples, for instance, in Netherlands, where there are additional doctors who are, through their medical association, trained in that particularly assisted dying. I can't tell you how many years in other countries. I just felt it was self-evident that you would want people, doctors who are experienced, 3 years, 5 years, whatever, post-qualification, who actually have seen real life. And it's up to the medical associations to stipulate how much. But I wouldn't like the idea that a doctor, immediately having got their certificate of training, is going off making these kinds of decisions. I think that that's why I suggested that ballpark figure.
Sorry, thanks, Chair. But just to clarify, there's no rules in the UK as well where we have that. I'm just trying to understand, it's a piece of work we need to go and do about, are there enough doctors with that level of experience if we were to take on that kind of recommendation? But there's no rules in the UK in the medical profession where we insist on that level of experience either.
Probably not, but this is a very, very special situation, and it may be that once it's become embedded in the health service, that maybe that stipulation could move back. I think I'm so glad that Dr. Clark keeps coming back to training. One of the things that I think is absolutely needed if this went forward would be to take the topic of assisted dying out of being an optional thing that people might sign up for a course to become mandatory training. I mean, in the NHS we do mandatory training for all sorts of things: washing hands, lifting, basic life support. There should be basic dying support mandatory training as well. Why isn't that there? So this would then become part of training doctors up to become good at those conversations that Dr. Clark's obviously involved in teaching, but also in keeping up to date with how the law is changing too. So I think training, and I would look to the Royal Colleges, the GMC, to actually be leading on those aspects.
Thank you. Thanks, Chair.
Thank you, and thank you for giving up your time. Very high level of palliative care expertise and experience. I'm actually a practicing GP, and GPs and district nurses do a lot of palliative care with a lot of advice from you people. But what I've also noticed is that even if you have absolutely best quality palliative care, some people still would have talked to me about an assisted death or shortening their death. That's what they've talked about. So would you? I'd just like to hear what your comments are about whether this is more about autonomy than symptom control.
Well, I absolutely agree that in a small number of cases, palliative care at the highest level cannot eradicate all suffering and cannot prevent a person from wishing to end their life and have assistance in ending their life. That's absolutely the case. Although I would say it happens surprisingly uncommonly in my experience, but it does happen. I think autonomy is the crux of the issue for me, because autonomy is predicated on having meaningful choices. Can you actually choose option A or option B? If option B is high quality, not just palliative care, but medical care in general, district nursing care, social care, if that is not available to you, you are potentially being pushed towards choosing, in inverted commas, option B, the route of assisted dying, not freely and not autonomously, but because actually option B has been denied to you by the real world failures, which we all know about. We're all familiar with the latest winter crisis where patients have been dying on trolleys and corridors, etc. The real world conditions that are preventing the actual option of a death in which dignity and comfort and even moments of joy can be maintained right up until the end of life, because that patient is getting the high quality palliative NHS and social care they need. I think that's the crux of the issue, because if you do not have that as a real option for patients, then we can say that they are choosing autonomously assisted dying, but actually society is coercing them into that so-called choice because it is not funding the care that makes them feel as though life is worth living. And that's why I think many of my colleagues are so concerned about legal change now. It's not because of an opposition to assisted dying in principle, it's because the actual real world conditions of the NHS today are such that people's suffering means occasionally they will beg me to end their life. And I know that that begging is coming not from, for example, the cancer per se, but because they've been at home not getting any adequate pain relief. And once you start to provide proper palliative care, very often that changes.
Move to Danny Kruger, please.
I'll just ask one question, if I may, to you, Dr. Cox. Dr. Clark said that the capacity assessment was poorly conducted. Do you think that the threshold is appropriate using the Mental Capacity Act? Are you satisfied, assuming that we could conduct these assessments adequately, do you think the threshold is safe?
I and my colleagues have concerns about the safeguards in the bill. Not just the capacity assessment, but also we acknowledge that prognosis is incredibly difficult to assess accurately. Coercion, I would say, you can't always identify coercion. You can identify it when it's very obvious and extreme, but when it's very subtle, we cannot always identify coercion. And after the event, there is nobody to tell us about coercion, so it's very difficult to monitor. I think that the other thing that concerns me is that we are putting all of these assessments on the shoulders of 2 doctors individually, followed up by a High Court judge, when in any other clinical practice, when we're making very serious decisions, we know that shared decisions are much better quality and much more robust and much safer. And in clinical practice, we make all of these decisions in multi-professional teams. So I would never make these decisions independently of my team, because the perspective they bring can help me to understand things that I'm not seeing. And so I think that's the thing that I think I'm really concerned about, is how is it possible for these doctors, even with training, to have a good understanding of all illnesses in order that they can identify prognosis, neurological, cancer, every other. How is it possible for them to really understand capacity when capacity is not an absolute? It does change. It is very complex to assess. How is it possible for them to see all cases of coercion, which can be invisible? And in addition to that, are they going to be looking out for opportunities to refer to palliative care when they see somebody who has suffering that could be addressed and may change their mind? Are they looking out for untreated depression? We know that treatment of depression, again, can result in people changing their mind about wanting to die. It's a lot to ask these individual doctors to do, and that really concerns me.
Thank you. Kit Malthouse.
Thanks, Chair. I just want to pursue that point a little, if I may, with Dr. Cox. I mean, my understanding is that your profession is already taking these decisions or supporting patients to take these decisions. So, for example, the withdrawal of ventilation for an M&D patient towards the end, or if I would decide to decline treatment, or food and water to end my life as quickly as I can. Presumably in those situations you have guidelines already or training about assessing coercion and capacity in those circumstances. And I think in some you're legally obliged, I mean, for example, advanced directives, legally obliged to comply with the patient's wishes. Are those guidelines, do you think, broadly, and those safeguards translatable across into what, I mean, from my point of view, is another choice that a patient may make to end their life?
So I think there's 2 differences that I would identify. I think the examples you give are of somebody that may be naturally dying and is being kept alive. So the difference is you're withdrawing a treatment, you're not intentionally killing them. This is the difference of assisted dying. So that's the first difference. And the second difference I would say is you're absolutely right, we do make those decisions with patients if they wish, with their families, but in a multi-professional team.
Mm-hmm.
So I almost never would make those decisions as an individual doctor without the support of my colleagues for several reasons. One, which I've said already, about the fact that it makes so much better decisions. They are safer, they are more robust. And the second is the moral distress that's associated with these decisions is much less if you share them.
Mm-hmm.
And that's also a worry for me, is what happens to the moral distress of these two doctors, the coordinating and the other assessing doctor. They're carrying a lot of moral distress, aren't they? And my understanding, it's going to be a very small percentage of all doctors that are going to want to engage with this. Maybe 1 or 2% of all doctors are going to want to be in those assessing positions. And they're carrying a lot of that distress because they're going to be doing a lot of assessing, aren't they?
Understood. Okay. The other question I guess I had for all of you, but particularly also Dr. Clark, was you've mentioned autonomy a number of times, and obviously what the bill is trying to do is to pass autonomy to the individual at a particular moment at the end of their life. And it feels to me that the picture painted is at the moment is a largely unregulated one. Right? I think you said, Dr. Clark, that there are no regulations or kind of guidelines about what is going on, and as my colleague Sarah Green said, there's no kind of monitoring or measuring of what's going on. So in general terms, given that patient autonomy is at the centre of this, would you welcome a set of rules that is understandable by patients and doctors, rather than what we have at the moment, which is a sort of casual negotiate, well not casual, that's not the right word, but an ad hoc negotiation at the time, depending upon what the patient wants to do?
Well, I think that's not quite right, and certainly not what I intended to convey. That there are rules, there are very clear legal and professional rules and guidance and protocols around how to have all of these conversations. However, in practice, the quality of the conversations is very contingent on the confidence, expertise, training and background of the individual clinician having the conversations, and there can be, I think, a great deal of inter-doctor variability in how those conversations are conducted. So in terms of addressing that, I would suggest that in an assisted dying scenario, the crucial thing there is to make the guidance and the training as robust as it possibly can be to reduce the inter-practitioner variability.
Very good. Sorry, I mean, sorry, I'm just conscious of time. We've heard this morning how vital training is, and I think that's broadly from a number of voices that's accepted. And then I just wanted to question you about this issue of the choice that people face. And I understand the point you're making about the variable state of palliative care versus the choice that someone face, but that's obviously a kind of macro standing up. Obviously, day by day, patients are facing a choice about what's ahead of them in the next few months. I wouldn't want to put words in your mouth, but I presume you're not saying that for the good of the whole you should go through this awful death that you don't really want to go to while we wait for palliative care to catch up.
Of course not.
Right,
and autonomy...
Excuse me.
Sorry.
Order. We've got half an hour left. We've had 9 people asking questions. We've got 8 people left to ask questions. If we want to get through to ask the questions by 3:15, people will really have to have a little bit of self-discipline in relation to asking questions. And again, to the panel, forgive me, we just need answers as reasonably as possible given the circumstances. If you wish to answer that one, the last point, feel free.
Yes, so very quickly, of course, we want as much autonomy for as many patients as possible. The issue is around safeguards. So if, for instance, you say to a vulnerable patient who's just been told they have a diagnosis of terminal cancer, have you thought about assisted dying? I would suggest that stating it boldly like that is a form of pressure, and potentially you are unintentionally coercing that patient, because the very act of raising a sister dying in that way will make that vulnerable patient think, God, is this doctor telling me that my life is not worth living anymore? So autonomy is much more subtle and complicated than we assume from outside.
Thank you. Julie Campbell.
Thank you, Chair. My question, I've got one for James Sanderson, one for Dr. Clark. They're quite similar, but I'm referring to things that you said or quotes that you've made. So, James, you said, sadly, only half of the people who need palliative care receive it. My question to you is, in your opinion, who are the people who do receive palliative care and those who do not? And then my question to Dr. Clark is very similar. You've said, or quote, the population is carved up into two groups, those who deserve to live and those who are expendable. Could you expand on that quote and also expand on the two groups you refer to and the impact that it has on their treatment and care?
Thank you. I think you draw a really important point around not just the provision in totality of palliative care across the country, but also the inequity of access. And we do find, unfortunately, that the diversity of people that are accessing care in hospices across the country is less diverse than those that are dying in hospital. 43% of people currently dying in hospital. And one of the things that I think we really need to do is move to a new ecosystem of palliative care that looks at supporting people in different settings. We do need specialist provision in hospices to support people with significant needs, but increasingly hospices are reaching out beyond their walls into the community. 80% of the work that Sue Ryder does is in people's own homes, and people tell us they want to die at home. So supporting people in their own homes enables us to access more diverse communities, enables us to get to people in their own setting. But increasingly, one of the things that we feel is necessary is provision of support inside hospital. And our alongside wards would bring support to that 43% of people who are currently dying in hospital to ensure that there is equality of access at all places, both in inpatient settings and in the community, because I think you draw a really important point that we've got to look at the totality of provision and ensuring that when somebody is offered palliative care and the Act talks about that provision being available, that there is universal access, and that is both in terms of the type of palliative care that's available, but the access to everybody in society as well.
Thank you.
And my comment refers to the fact that there is an immense gulf between the theory of the NHS being a cradle-to-grave service, a service that cares for us at the end of life as it does at the start, and the reality. And the reality that I see every day at work in my hospital is patients coming into the emergency department from the community in sometimes utter, abject misery, agony, lack of dignity. They have been forgotten completely. They're not getting health care, they're not getting social care, no one cares about them. Even in the hospital, patients sometimes who have a terminal diagnosis are cast out into the corners of the hospital. There are hospitals, and mine is one of them currently, where we don't even have a 24/7 palliative care service face-to-face. So for every night in the hospital and every weekend, Friday to Monday, you cannot see a palliative care nurse or doctor in my hospital, despite the fact that for a number of years that's an NHS standard. That's an absolute disgrace, and it shows how little people who are dying are truly cared for in a civilised society. And this doesn't necessarily have anything to do with assisted dying, except if we do not address that simultaneously, then some of those people will choose, in inverted commas, to end their life because we as a society don't care about them enough to give them the care that might make life worth living, and that's a travesty, surely, for Britain.
Thank you. Thank you.
Thank you very much, Chair. Can I turn to the subject of registration of deaths, which is dealt with at clause 29 of the bill? And it's a question to Dr. Clark and Dr. Cox, whether they feel that the provisions set out there are sufficient, and if not, what further bolstering of those would provide the oversight that the processes and procedures are being followed correctly.
So my understanding of the plan is that in the bill, forgive me, I'm sketchy on this, but that the aim would be the registration would be as a natural death. It would not be referred to the coroner, and assisted dying would appear on the death certificate. I'm also a medical examiner, and my concern around this is, as a medical examiner, I'm obliged to scrutinise all deaths by law to ensure that a referral to the coroner is not required, and to identify any learning. And what concerns me in that role is there enough recording that's happening around decision making and the process that I can actually do my job properly with my medical examiner hat on? Do I actually know what happened? Because I don't see in the bill anything written down about the records that are being kept, what happened when the patient took the substance, what happened afterwards, and any actions that were taken in the meantime. I think this is not so much something that, with my palliative care consultant hat on, is something that I've thought about a lot, but as a medical examiner, that does concern me.
I'd ask the same question of Dr. Clark, if I may.
For the sake of time, I don't have anything to add. I completely agree with that.
Great.
Thank you, Chair. Dr. Cox, just to follow up on one of the things you said earlier, if that's okay, and forgive me if I've misunderstood, just be really clear. I think one of the things you said earlier was that in the countries where they didn't have assisted dying, the state of palliative care had improved more quickly than the countries that did. Is that a fair representation of what you said?
European countries and American states.
Sure. I mean, in terms of the UK, would you say, and you've painted, I think, the whole panel, and we've heard previously a pretty bleak picture of the state of palliative care in the UK. Would you say it's better or worse than it was, say, 10 years ago?
Well, I suppose it depends who you are. Because if you live in one of those postcodes where you can't get palliative care, if you are socially deprived, if you're a member of an ethnic minority, if you have a non-cancer diagnosis, then you're not going to get very good palliative care in this country. And I think that's awful.
Yeah. So I guess what I'm sort of driving towards, is that simply not having assisted dying, for example, isn't necessary causation for improvement in palliative care in this country, for example. We haven't seen palliative care improve from where it was 10 years ago, last time this debate came to government, for example.
I think the position that we would ask you to consider is this the right time to be bringing in a law to give people a choice for assisted dying when they don't have a choice to have good palliative care?
And I think that's a really fair argument. I guess what, again, I'm driving towards is that point you were trying to make earlier, I think it's fair to say, which is countries that don't implement assisted dying improve their palliative care system. That clearly hasn't happened in the UK. So what I guess my question, it's not direct causation, is it? There's a number of other factors. I agree with you.
The NHS is very different to any other jurisdiction.
Yeah, so what I guess is the direct comparison isn't necessarily relevant. Is that probably correct?
Can you address it through the chair? It's not
Sorry.
a dialogue.
Yeah, sure. Just to kind of drive through.
I understand that, but can you address it through the chair? This isn't a dialogue.
Thank you, Chair.
Thank you, and thank you for the question. Palliative care may well have improved in this country over those years. That it has also improved in the countries where assisted dying wasn't available. What we're saying is that there has been chronic underfunding of palliative care, and so where we are at now is inadequate.
Thank you, Chair.
Thank you, Chair. It sort of builds upon that point, actually. That was pretty much what I was going to ask. And that's what I'm sort of trying to get to here. Is that the evidence that we heard, well, not we heard, but the Sue Ryder's evidence to the Health and Social Care Select Committee inquiry into assisted dying gave examples exactly of that, where increases in funding of palliative care came alongside the introduction of assisted dying. So I think you talk about people can't have a informed choice unless palliative care is fixed. do you accept that the improvements can run in parallel for both assisted dying and palliative care, and that for the small number of people who palliative care can't help and can't, reduce their suffering, that they're left without a choice currently?
I accept that there will be people, even with a very good palliative care system, who would still choose assisted dying. We do not currently have the very good palliative care system that we need, and that's the thing that concerns me.
So building upon that, what would the optimal, what further steps do we need to then improve palliative care, and how do you ever define when palliative care is sufficient to then allow assisted dying? Because that's what I'm struggling with, is how do you say, we've reached that threshold? Is that ever going to be a point where we can say we've got the best palliative care?
So I'll give you some examples of that. We need to make sure that the 75 to 90% of people who are dying that need palliative care are getting it. We need to make sure that there is not inequity in palliative care, that you don't have to be white and rich and have cancer to get good palliative care. We need to make sure that hospitals have 7-day services. 40% of hospitals have no cover 7 days a week. We need to make sure that communities have telephone advice services at night. 1 in 3 don't have any advice overnight for patients and their families to access. So there are some very concrete things that we could change to demonstrate that we are delivering a good service, but currently we're not.
So building upon from that then, obviously we've seen since the assisted dying bill was read at second reading, we've seen announcements from government about investment into palliative care. Obviously that's mostly capital. We need to see more long-term funding. But do you feel that, the point I'm trying to get to here is that we're seeing increases already as a result of this conversation. So is there any reason why that shouldn't continue?
I would love to see it continue. I'm part of the Commission on Palliative and End-of-Life Care. There is no guarantee that the recommendations of that commission will be funded. And that's what concerns me. So I would love to see that happen. Wouldn't that be great if the two could happen simultaneously? There is no guarantee that will happen.
Thank you.
Chair, if I may, just on the point that you've made, and agree with Sarah's points. Obviously, we welcomed the government's announcement of the additional funding for the hospice sector, but the committee will be aware that the hospice sector currently receives only about 30% of its funding from statutory sources, and we are therefore reliant on the goodwill of the population to raise money and support us in various ways, and through retail and other ventures that we have. I think the point about universality of service, we have within the Care Act, within the 2022 Care Act, a requirement of integrated care boards to commission palliative care services that meet the needs of their population. But actually, whilst there's guidance in place of what that should look like, there isn't a universal take-up of that guidance and the delivery of all of those services that are stated. So whilst it's outside of this bill, I understand, I think, again, it comes back to that context of how much that overall position can be strengthened across the country. So the context for anybody looking to make a decision is within the same space, and that's what we've said about that Dr. Clark has said around that informed choice. If the context is the same for everybody, then that we can have more confidence that informed choice is right and at the right level.
Chair, goodness me, there's a lot to cover. I think to go back to your initial point, Mr. Sanderson, in terms of palliative care professionals and what a fantastic job they do, I think it's very important to acknowledge that. And indeed that we're having these conversations, I think is extremely important. That's why we give extra time to this particular panel. Just a few points. On Dr. Cox, your point about the pressure on the individual doctors who are involved in this process, I think the bill is very clear that if they don't have the specialism, they must refer to a specialist in that condition. And they can refer to a psychiatrist. I think there's probably consensus that maybe we should need to strengthen the bill in that regard, whereas the doubts around capacity, they probably must refer to a psychiatrist. It's certainly something I'm taking away from these sessions. I was very interested in your comments about this multidisciplinary approach. And we've heard from colleagues this morning from social work and from nursing around that. And I'd love to know, Dr. Ahmedzai, your thoughts on this idea of a multidisciplinary approach. I think there's a lot of value in that. And Dr. Clark, if I may, to you, this concept around training. I mean, I think it worries me that we've seen a very different picture painted by you and others this afternoon from what we had this morning, where we had doctors and nurses telling us that they regularly assess for capacity and coercion. This is a part of their day-to-day work, and they were very confident in their abilities to do that. So I think training is absolutely fundamental. And I think this is an opportunity to look at gold standard training. I'd be interested to know your thoughts on that. So I think one for Dr. Medzai and then one for Dr. Clark, if that's okay.
So you were asking me about the multidisciplinary nature of this. I'm really glad you raised this, because we seem to be focusing on palliative care as being very professional, and I would remind people that actually there are levels of palliative care, and a lot of palliative care is not given by specialists like the three of us here. They're given by generalists, either GPs, as we've just heard, or by oncologists, geriatricians. And so when we talk about increasing palliative care, improving palliative care, it's not just about more doctors like us sitting and giving out specialist level. I think the other thing is, yes, it's not just doctors. We've got to acknowledge that probably in the front line have to be nurses who do so much more than doctors. You know, at the bedside, when doctors clock off at 5 o'clock in those sad institutions that still don't provide 24/7, there are nurses there all around the clock. And then obviously there are social workers, physiotherapists, lots of them. And I think it's vital that if we're talking about meeting the needs of people who may not necessarily have pain, but to have other forms of suffering, worries about not even physical, but loss of dignity, loss of independence. Nurses are so good at supporting people in that. A doctor will just get in the way. But actually what we need to do is to make sure that we're addressing the reasons why many people, I know from speaking to people abroad, why they choose it, because it's loss of dignity, loss of independence. And isn't that a legitimate reason for wishing that you weren't a burden on somebody, on the state even? So, yeah, I think it's really important that we consider that. Just the other thing to bring in there as well, if we're thinking about the big picture, I have to say, another elephant in the room is that palliative care is not, strictly speaking, actually in the NHS. Not all of it. A lot of it is outside of the NHS for historical reasons from 50, 60 years ago when decisions were made. And although there are excellent charities providing, discrete areas of it, we rely so much on non-NHS services in a way that you would never think of going to a charity to get your heart transplant or to get your kidney, sort of treatment, your dialysis. I think we need to confront the fact that palliative care is fractured because of that history, because of the genesis of how palliative came to be. And not just NHS, but we must think about the multidisciplinarity.
And regarding training and how much it's required, I think that I wouldn't be the first person to make the observation that sometimes doctors can be very pleased with their own abilities at a particular practice, and that practice might be having a conversation where you're assessing someone's capacity. What's interesting as a palliative care specialist is, so I will be asked, my team will be asked to get involved with patients in every possible bit of the hospital, surgical wards, medical wards, intensive care, emergency departments. So you actually see a huge number of patients being treated by many, many different teams, many different doctors, junior and senior, all of whom are having these difficult, nuanced conversations around the end of life with varying degrees of skill. And of course, there are some doctors and nurses who are superbly skilled at having them. And I would say there are many, many who are not. And the reason training is so important is it's a little bit like Donald Rumsfeld's unknown unknowns. You might not even be aware of the fact that you have caused a patient or their family distress, because in a conversation where fear is a dominant part, the patient is fearful of suffering, misery, loss of dignity at the end of life, but they may not voice that. You as the doctor can be completely oblivious of the fact that you've sort of stamped over those unvoiced fears with your hobnail boots. You're not aware of it. And this idea that the patient, a vulnerable patient, needs to be absolutely at the centre of every conversation you're having, I would suggest is quite radical in some parts of the NHS, and it needs to be taught much more assertively from day one of medical school, so that vulnerable patients are always at the centre of the room. And that's why I think the single most important thing for the bill and its safety comes down to training and actually recognising that these conversations are difficult, they are nuanced, and if we assume that, we're going to make sure that a bill is as safe as it can be.
Yeah, thank you. Can I have one quick follow-up, Chair?
Well, I will come back to that if once I get other members in, if you don't mind. Lewis Atkinson.
Thank you. Question to Mr Sanderson and Dr Cox, if I may. Clause 35 of the bill, as currently drafted, introduces a duty on the Secretary of State to report on a periodic basis to Parliament about the accessibility and quality of palliative care. I was just wondered if that's, I think as I understand it, that would be a new duty that's sort of quite pioneering. What your reaction on that would be, and whether you think that would be helpful in continuing the momentum to make improvements to palliative care, and indeed if there are any further reporting requirements as part of that assessment, for example around equity of access that I know some people have mentioned that we could maybe consider when we're considering amendments, etc.
So thank you. I welcome the provision in the report. I think what is necessary is a benchmarking of the current position rather than sort of waiting a significant period of time to do a review. I think we need to benchmark the current state of palliative care and then base obviously subsequent reviews on any changes. I think, as I mentioned before, I think we also need to look at the wider context. If we look just narrowly at the provision of palliative care, I don't think we'll properly see what goes on across the whole environment of the health service and in social care as well. We've mentioned about the fact that district nurses, general practitioners are providing a huge amount of palliative end-of-life care, so it may not just be what goes on inside hospices and in palliative care teams in hospitals. And I do agree that I think that needs to look at the demographic information so that we're collecting details on who's accessing palliative care and where, and there's certain types. I think all of that is necessary as part of that review.
Yes, thank you. I would agree completely about the fact that we need to be doing that review now and in the future regularly in terms of the palliative care aspects, but I also think there's an opportunity to write into the bill other monitoring that would be really helpful in ensuring safety on an ongoing basis. So monitoring in terms of decision making, how often the assessing doctors refer to others, how often they disagree, what happens after the declaration. In the bill there is, as far as I could see, no limit to the delay between the declaration and the request for the substance. So that would be a really interesting thing to look at in the future, wouldn't it? Because potentially somebody could delay 6-8 months, and do we do another capacity assessment then? That's a tricky question. What about the taking of the substance?
Okay.
We haven't talked about that, but I mean I think there's a lot of things that we could look at in the future that would be really helpful to monitor.
So just on one particular point, if I may, I think it's around 650 people currently who take their own lives with a terminal illness, etc. I wondered if there was an element of, if we would see a success of this bill around the reduction of that number going forward, and whether you think that could be incorporated in monitoring going forward, and what opportunities there are, you think there are to avoid some of that suffering that clearly people are experiencing traumatic deaths at the moment as part of the monitoring of this bill?
So it's really difficult to know, isn't it, how many people die by suicide because of their terminal illness that would instead access assisted dying. And it's really difficult to understand the impact of an assisted dying legislation on that. If we look at the evidence of suicide, we know that suicide is increased in people with serious illnesses, but it's actually increased in the first 6 months after diagnosis. It's not increased in the last 6 months of their lives. So it's around the trauma of the diagnosis. And what I would say we need for that is we need better mental health services, and we need better support around diagnosis, earlier palliative care. And the other piece of evidence that I would offer to you is that the universal picture, the global picture around what happens to suicide rates when assisted dying legislation is introduced is confusing. It's mixed, but there are jurisdictions, for instance Germany, where after the introduction of assisted dying legislation, the incidence of suicide has gone up year on year. So I don't think we can say that introducing an assisted dying bill and legislation will actually stop those suicides.
Thank you. Rachel Hopkins.
Build on some of the comments around the multidisciplinary teams that you all, do your great work within. The Chief Medical Officer said earlier in one of the sessions earlier about discussions around death and dying and end of life are increasing. They are getting better. But importantly, when we heard from the RCN, Professor Ranger, and the Association of Palliative Care Social Workers, they also talked about those conversations they have as part of the wider team. And quite often it's those healthcare nurses having those conversations. And I was really struck by the way they talked, both the RCN, around, and you used the word as well actually, not being paternalistic, about having the patient at the centre of that conversation and ensuring we listen to the patient and ask them, what is it you want? And that for me is all about autonomy. Do you agree the emphasis must be on patient autonomy and their choice at the end of life?
100%. And sometimes those of us who work in palliative care almost see the extent to which we try to place the patient at the centre of everything as quite radical when contrasted with a lot of the other medical specialties. My opinion about what's best for a patient does not matter. Their opinion is what counts. And the power of the multidisciplinary team and the reason for thinking it may be worth considering amending the bill so that there is a greater role in the legislation for a multidisciplinary team is this. It's the fact that everybody in that team brings their unique perspective. So whenever there is a tricky issue in my hospital regarding a palliative patient, we will have an MDT, and there may be 10 people in the room all discussing the issues, and this might be someone has decided they want to withdraw their life-prolonging treatments, or they want to have life-prolonging treatment, and for whatever reason it's really complicated. And we will have the patient, their family, doctors, nurses, social workers, dietitians, a big group of people, because that is the way to make the decision most safely and most effectively in terms of enabling the patient to have the treatment that they wish. And it's incredibly important to have that.
Mr. Sanderson to reflect on that for the different contexts.
Order.
Sorry, Chair.
No. We've got 2.5 minutes to go. There's one other member who wants to ask a question, and with the respect to the member, I want them to come in with that question. Sarah Olney.
Thank you, Chair. Just quite a quick question. It's to Dr. Cox. Earlier on you were talking about, in the context of multidisciplinary teams, but you mentioned the family and how important the family of the patient was. There's currently no role in the bill as it's currently drafted for the next of kin or for any family member. I just wanted to ask you, do you think that's a mistake? Is that something we should look to amend?
I think it's a choice of the patient, and it's always a choice of the patient who they want to involve from their social circle, whether that's family, whether that's friends. But I think if the patient wants the family involved, then they absolutely should be, and they should be part of those conversations and discussions.
Thank you. Thank you, Chair.
One last question, very quickly.
Very quick one. You talked about inequality in healthcare and in systems. I mean, what I would like to come back to is the status quo. What are your comments on the inequality that exists currently, where we have assisted dying available to people who have got the money to go to Switzerland and have an assisted death or another jurisdiction? Sam Ahmedzai, maybe first of all.
Yeah. Clearly, we've had that option. British people have had that option for many years since Switzerland offered that. And it's clear that two things that happen. One is it's selecting out people who are better off, more functionally capable. They can do that, so it discriminates against disabled people. But also, people tend to do that long before they need to, when they're still actually fit, because they mostly want to go on their own without dragging relatives along. So it's doubly damaging to families who are experiencing, going through an illness with somebody that's dying, that they have to say goodbye to them long before they ever need to do that. But that's because we do not offer that option here.
Anybody else? Anybody else want to comment, Dr. Cox?
Happy to quickly. Of course, we don't want people to have to make that choice. And I would refer to everything I've said before about, are they making a real choice? Have they had access to really excellent palliative care? I would also make a very brief point about the impact of the discussion about what dying looks like that this bill has raised, and the fact that the stories that have been told have suggested to many of the public that death is inevitably ugly and horrific and dramatic. And actually that's made many people fearful who have been emailing me and saying, I'm now afraid of dying and I wasn't before. And they may then choose assisted dying before they need to, because they have had a fear instilled in them that death is inevitably horrible and dramatic.
But those deaths do
Thank you.
exist.
Order.
Actually
Order. Please. That brings us to the end of the time allotted for the committee to ask questions. I thank our witnesses on behalf of the committee for their evidence. Thank you. We will order. We will now hear oral evidence from Sir Max Hill, former Director of Public Prosecutions, Alex Wood-Keane, barrister specialising in mental capacity, and Sir Nicholas Mostyn, who is a former High Court and Court of Protection judge. For this session, we have until 4:15 p.m. And we may possibly be interrupted by a division, so just bear that in mind if you would. Could the witnesses please introduce themselves to the record, starting with...
Yes, good afternoon. I'm not sure how much you want by way of introduction, Chair, so please stop me. But I was the UK Independent Review of Terrorism legislation 2017-2018 and Director of Public Prosecutions 2018 to 23, so I stopped 15 months ago. I'm not a campaigner. I'm here to bring any experience I may have picked up along the way of criminal casework, which was part of my diet as DPP. But I have been quite close to the construction of the bill and happy to deal with any questions that I can.
I'm Nicholas Mostyn. I was a judge of the High Court Family Division and of the Court of Protection and of the Administrative Court until 2023, when I retired with the onset of Parkinson's disease, which is a genuine slippery slope, unfortunately. And I'm now a podcaster and devoting myself to alleviating the hardships of people living with Parkinson's.
So I'm Alex Wood-Keane. I am a barrister in independent practice, and I need to emphasise that I'm giving my evidence today as a self-employed barrister, not on behalf of any organisation I'm associated with. You would have seen from my written evidence I'm associated with quite a few different organisations because my practice and my career straddles both advising and appearing in court cases involving mental capacity. I teach law at the end of life as a professor of practice at King's College London. I'm also very heavily involved in law reform in different ways. I was, for instance, the legal advisor to the Independent Review of the Mental Health Act. I also do an awful lot of training, to the extent relevant, in the context of mental capacity of both healthcare professionals and social care professionals.
Thank you. Now I'll ask members if they want to ask questions. I'd ask Matt Shaw first.
Thank you, Chair. Thank you very much. Just one question for Sir Max, please. Sir Max, you have said that you are very concerned about the CPS during your time as DPP having to investigate people who accompanied their loved ones to Switzerland to end their lives. And I share that concern. My understanding is, however, that around half of those who currently visit Dignitas would not actually qualify for assisted dying under this bill because they didn't have a diagnosis of 6 months to live. Is this bill the right measure to solve the problem you're actually worried about?
Well, if the problem is anybody in future going on their own or accompanied by their loved ones to Dignitas, the answer is no. This bill does not satisfy that. But I think what we have learned from other jurisdictions around the world, where we see broader groups or multiple groups beyond the terminally ill who are entitled to use new legislation, that has not been the model for this legislation unless you and Parliament were to dramatically change it. So I think the nuanced answer to your question is that this bill does provide an opportunity for those in the category of being terminally ill, as defined in the bill, to no longer have to resort on their own or supported by loved ones to going to Dignitas. So yes, it can and will make a positive difference. And I should add, if I may, in answering this, that my personal experience, often quoted, is that 27 cases investigated as assisted suicide came across my desk, my own desk, as the DPP, so 5 to 6 a year. A substantial proportion of those cases did involve Dignitas because an accompanying relative who had returned alone was then investigated, but a proportion did not involve Dignitas at all because there had been deaths at home. In all of those 27 cases, I only made the decision to prosecute in one, and that was an individual who was 19 years of age encouraging another teenager to end their life, and that was a correct and successful prosecution. I would also add, though, because until 15 months ago I was a prosecutor, and prosecutors look to bring criminal cases whenever the law is broken, that there were an additional handful of cases in which, although not making the personal decision, I supported authorisation of charges for murder or manslaughter in those cases where it was clear that an individual's life had been brought to an end, not at the time of their choosing. And it's perhaps important to remember that this bill, as and when passed, matter for Parliament, would not truncate the homicide jurisdiction in this country. It will still be possible to prosecute for murder in those cases that one would expect to be prosecuted for murder. I feel it's important to say that as a very recent former prosecutor.
Thank you. So just following up on that, the ones that you did authorise prosecution for murder or manslaughter, was there ever issues of coercion involved? What were the ballpoints, the top lines of those?
Well, it's interesting. Those cases, that small handful of cases, involved an elderly couple where either it was usually he or she, had chosen to bring to an end the life of their lifelong partner, and once that had been done, once that act had been carried out, claimed that it was an assisted suicide in circumstances where the surviving partner was merely carrying out the wish of the person now dead. And there are a handful of cases in which that's clearly wrong, should not be accepted, and murder should be the offence that's brought before the court. The point, of course, though, is that throughout the time I served as DPP, and indeed all of my predecessors, we did not have the coercion offences which are created within this bill, which I would suggest would be a significant advance, nor did we have a legal system in which the investigation was taking place until before the death. It was the other way around. So in each of the 27 cases I considered, the deceased individual was already dead And that is when the scrutiny started. The major advantage, if I can put it this way, of this bill is that will be reversed and scrutiny will be before death. And in the case of coercion, where it fits the new potential clauses, prosecutions can, and I'm sure, will be brought.
Thank you.
That's extremely helpful to understand the opportunity for scrutiny before death. And building on that, are there any safeguards around those practices that aren't currently included in the bill but should be, particularly around detecting coercion and exploring alternative care options? And I have one follow-up, if I may.
Well, I think that coercion and the coercion clauses in the bill should be read alongside the capacity clauses, because what we're looking for, and as required by Section 1, subsection 1 and 1.2, is a clear, settled and informed wish, voluntarily made, without coercion or pressure. Those are aspects which were taken, at least in part, from the Crown Prosecution Service guidance when looking at 1961 Act cases. But capacity involves understanding information, retaining it, using it, and communicating it. And so if those hallmarks are not there, you may be in a situation where you should be considering coercion. So I think you read the two together. But to answer your question directly, the criminal liability sections, Section 24, the new offences in Section 26 and then 27, are robust as a matter for your scrutiny. There are aspects that we do not have in the law at present. And there is, of course, the addition of Section 36, in which you cannot be a witness or a proxy to the procedure that's enshrined in the bill if you're too close to the terminally ill person. So that is another hallmark of the bill that will hedge against coercion.
Okay, and just to follow up, because it's really important in terms of strengthening the bill, the definitions of coercion, pressure and dishonesty, based on your prosecutorial experience, what key elements should be present in those definitions? And a bit of a technical one as a follow-up, if I may. Do you think they would be better placed in Section 26, Clause 26, or in Clause 40 under the section around interpretation? So it's the key elements, more that you could say on the key elements of coercion, pressure, dishonesty, and then the placement in the bill so that it's as accessible as possible for all those medical practitioners and patients who will want to rely on it.
Yes, my inclination is that Section 26, which is part of the full body of the bill, is the right place for this. But as with the interpretation section in Section 40, and as with the way that we interpret statute as a matter of course, there are aspects of other statutory offences or acts of Parliament which help us when we're seeking to determine what coercion is. The creation of the offence of coercion and control, now very commonly used in domestic abuse investigations and prosecutions, has brought us into this territory. And it's not beyond the wit of anybody seeking to use and interpret this bill to also look for other parts of statute which deal with coercion. I'd make the same point about capacity, where what's in the bill is very slender, one might say, because it's inviting the reader to simply look across under Section 3 of the bill to the Mental Capacity Act of 2005. But that act is very clear on what mental capacity is and how it is defined. So I think what I'm saying is that from it's a drafting point, and I'm not a parliamentary draftsman, but I don't have a problem with the definition of dishonesty, coercion and pressure being in Section 26 where they are, but it's not the only place that one would look. There are other sources available.
And just to push, Chair, on the elements of dishonesty and pressure, you've helpfully acknowledged the link that we need to make on coercion to strengthen this, but on those two other elements, is there anything else that we need to look to make this more robust?
Well, dishonesty is a term of art in common use, but it is also a term of statute. And so anyone investigating or still more prosecuting would understand what dishonesty means. I accept that there's a wider point, not so much for interpretation, but for understanding, which this committee may want to consider, of how much of that already existing definition needs to be imported into the bill. But as with mental capacity, I'd suggest, beyond perhaps the odd footnote, it is not necessary for you as a committee to define again what dishonesty means, because we have it elsewhere.
If I could just very quickly add on pressure in particular, I think the committee would be really assisted by having a look at the learning of the High Court judges exercising their jurisdiction under the inherent jurisdiction in relation to people who are said to be vulnerable, because they have developed an awful lot of tools where they are trying to look at people in complicated situations, potentially with impairments, but not necessarily with impairments, where they are caught up, and one person brilliantly described it, being caught in a spider's web. And so those are the sorts of sets of tools where judges are trying to work out what is going on, and is it the side of the line we consider to be acceptable, or is it the side of the line we consider to be unacceptable? Because pressure is doing a lot of work there.
Thank you.
Thank you all for your written evidence. So Nicholas, in your helpful written evidence, you adopt Sir James Mumby's criticism of the current proposal for judicial oversight, and you instead recommend what you call a Spanish-style specialist panel. I just wondered if you could set out for the committee what you see the benefits of that approach is as to what might be described as the stark judicial oversight of a High Court judge.
Well, if there were how many? 6,000. If 1% would be 6,000 deaths a year. That was 6,000 deaths a year, and if each took 2 hours to process in the High Court, and you've got to read it, you've got to hear the evidence, one of them has to be oral, and you've got to write a judgment. So that's 12,000 hours. Well, each High Court judge does 1,000 hours in court, and outside court they do lots else. So you're talking about over nearly three quarters of the entire family division doing nothing but this. So it is impossible, in my opinion, for this to be done by the High Court, and it should be done in the Spanish way by a panel set up. As in Spain, the chairperson of the regulator sets up a panel for each case, a doctor and a lawyer. They have to agree, and they check that everything has been done lawfully. They don't make any value judgment about whether it's in the person's best interest. They check that it's all been done lawfully. And interestingly, in 2023, 10% extra denials were done by the panel. So I don't know whether that was because they were concerned about voluntariness, or whether they were concerned about suffering, because the criterion is suffering there, but an extra 10% was done by the panel. So the panel wasn't just rubber stamping, they denied an extra 10%. And I believe that an ad hoc system like that, a doctor and a lawyer doing a check, would be the best way of doing it, because the High Court, trust me, I've just come from there, has not got the capacity to deal with this 6,000 cases of this nature.
If I may just quickly come back, and I'll ask Nicholas, apart from capacity, which I appreciate, is there any other problems that you see with the judicial oversight clause? I think it's clause 7. In terms, sorry, is it 12? The relevant 12. Forgive me.
12. You hopefully threw me there.
The clause, apart from capacity, is there any benefit from the Spanish model that you see? And then I'll just, while I've got you, Alex, if I may, you similarly criticise the current judicial provision, and also you say in your very helpful written evidence of paragraph 10 about perhaps we need to consider a multidisciplinary approach, and that's been coming through the evidence.
Can I just answer before he goes?
Yes, I'm sorry, otherwise I'll get cut off, so I was trying to get to
ask the question.
I said earlier on, this isn't a dialogue. Can you address your comments to the chair, and I'll decide who and when people speak. I don't wish to be rude, but everybody's got to have their fair share.
Forgive me.
Yes, I don't know if you've seen Sir Stephen Sedley's memo, which came today, where he has suggested the official solicitor should be the checker of these facts, which seems a sensible idea. The official solicitor would be able to recruit more staff to do this. It wouldn't be nearly as expensive as High Court judges, of course, and it would be an efficient and way of dealing with the problem. The advantage of the Spanish system is you have a qualified doctor as well as a lawyer doing the checking. Remember, a High Court judge is not going to be a qualified doctor, and so that is a significant advantage in my opinion.
Can I just put that question? Okay.
Kruger.
Thanks very much. Just wanted a quick question for each of you. So Matt, as you point out, the bill doesn't repeal the ban on assisted suicide, and it would still be illegal to assist someone to go to Switzerland. Alex Goodman Casey, I think, doing an opinion on behalf of Dignity and Dying, the campaign group that champions this bill. In his view, it's more likely that there would be prosecutions for people who assist their relatives to go to Switzerland once this bill was passed. Do you share that view?
I'm not sure about that. I think that in terms of... So I would always default to the Code for Crown Prosecutors and the two tests that the prosecution must go through regardless of the crime that's been investigated. The evidential stage test sets out what it is necessary to be able to prove to, some people say, a reasonable level, to afford a reasonable prospect of conviction. And one can well imagine that in Dignitas cases, that hurdle, that test, is often satisfied. Often satisfied in the cases I considered, could often be satisfied in the future. But that doesn't mean that a prosecution results because the evidential stage test is satisfied. And that's because prosecutors must then go to the public interest stage and consider the non-exhaustive list of factors which are set out in the public interest stage test, together with other policy which, in the case of this area of law, has developed since the legal case of Purdy in 2009, where, in common with many other forms of crime, there are some policy considerations, legal policy considerations, which a prosecutor is entitled to consider. Now, they start at the very obvious. What is the age of the suspect? Because here one's not thinking about the deceased who's gone to Dignitas. What is the age of the suspect? What are their own characteristics? Have they ever committed a criminal offence before? What is their proximity to the case? What motivation did they have, emotional or otherwise, to lend assistance that technically means they've committed the offence? And I'm going through that because I said that a proportion of the cases I considered were Dignitas cases, and it was often at the public interest stage that I determined that a public prosecution was not necessary. And that is because after full investigation it transpired that the surviving relative had acted wholly out of compassion and, may I say, love for the deceased, was not seeking any gain for themselves, far from there being any dishonesty before or after the fact. And that would still remain. So it doesn't follow that were this bill to pass and were people then to take elderly relatives to Dignitas, they would necessarily face prosecution. But the premise to your question is, could they? The answer to that is yes.
Okay, all right, thank you. I mean, Sir Nicholas, you might want to comment too, because if it's and I've got a question for you as well, but I mean, if it is the case that there's more likely to be prosecution, maybe you disagree.
Sorry.
You don't disagree, because in that case, this bill would be worse for somebody in your condition, with your condition, because it doesn't address your condition, and it would put your relatives at greater risk if they did assist you. But you don't think there's a danger of prosecution?
I think it's unlikely. I'm sorry for interrupting you. I always used to say, don't interrupt it. I'm sorry about that, but I fear that I will be, as the lady asked the first question, I fear I will be one of the people who has to go to Dignitas. Frankly, I could afford to do that, rather because this bill is not ever going to provide an assisted death for me, and I'm not going to be graphic about what the advanced stages of Parkinson's is like, but the medical members amongst you will be able to describe what is likely, not definitely, I don't want to say definitely, but likely to await me. And so it is going to either be a poor death, I'm choosing my words carefully, a poor death here, or to go somewhere like Dignitas. And I would be extremely surprised if my children took me as far as Calais. Of course, but they helped me after Calais. The assistance only applies to within the jurisdiction. If my children take me to Calais and then drive me on to Zurich, I would be very surprised if any prosecution ensued. Very surprised.
Thank you very much. Just because time is tight, I wanted to follow up further, but I'll just jump to Mr. Rutkin, if I may. Could you explain a little bit about your concerns about the Mental Capacity Act and its interaction with this bill? Do you think the threshold is of capacity is adequate that's set out there?
So I think there are two different questions, if I may. One is any idea of capacity sufficient at all? I think that's an existential question which I'm just going to park, if I can then turn to the Mental Capacity Act itself. I think it's important to understand there are three different bits to the Mental Capacity Act in play. So we've got a set of principles. So the presumption of capacity, the presumption you have to provide all practicable support before you find someone to lack capacity, and the idea that you can't, just because a decision seems unwise, you can't say that someone lacks capacity, so you've got that. Then you've got a functional aspect. So in other words, can you understand, can you retain, can you use and weigh the relevant information, can you communicate their decision? And then you've got what some people call the diagnostic element. In other words, is there an impairment or disturbance in the functioning of the mind or brain? So there are three separate things, all of which we make work more or less in everyday practice. I should say more or less. I was on the advisory group for a project funded by the National Institute for Health Research yesterday, funded in 2022 to try and increase the quality of mental capacity assessments in the healthcare setting. So I think we need to be under no illusions about how well we're doing it at the moment, but we make it work more or less. But the Mental Capacity Act works more or less in the healthcare context because every time we reach the view that someone can't make a decision, we've got an alternative. We can think about best interests. What we're asking the idea of mental capacity to do here is different, because there is no suggestion that if you can't support someone to make a decision, will ever make a best interest decision in their name to assist death. It's also not obvious that the idea that a presumption of capacity should apply. So if I doubt that you have capacity to make the decision to take your own life or end your life, but I can't prove it, is it logical or are we required to proceed on the basis that you do? And also, it's not immediately obvious that it's right that the diagnostic test applies in this context. So in other words, I think you can't understand the information, but I can't prove the reason you can't understand it is that you don't have that you've got an impairment or disturbance. So I think that's where my concern when I was explaining it in my written evidence comes in. But can I be absolutely crystal clear, totally crystal clear? As far as I'm concerned at this stage, this is policy development. I'm so glad that evidence is being taken and the public bill is drafting, or is thinking about this. But a bill of this nature needs to be drafted by Parliamentary Council. So what I'm really trying to get across is the policy line. And to me, the policy line is what doctors need to be interrogating, and anyone else, because I would love it if other people were involved, is that what doctors are interrogating is, can the person understand the information? Can they retain it? Can they use and weigh it? And can they communicate their decision? And if they can't, we don't need to start mucking around with why not. It's just that they can't. And so that is the central idea of capacity, the functional idea, but it's tooled for use in this Act rather than, as it stands at the moment, just being cross-referred out to the Mental Capacity Act and raising a whole series of additional complexities. And my only other observation is I spend an awful lot of my life trying to improve Mental Capacity Act practice more broadly. I would be massively, massively concerned were a knock-on effect of this bill seeking to deal with a very specific group of people to start inadvertently, and it would be inadvertently, interfering with how we think about healthcare decision-making more broadly in the context of those people with impaired decision-making capacity. So it's an insulation point, this is the right, making sure you've got the right tools for the job point, and it's not having a knock-on impact on thinking about things more broadly point. Sorry for the long answer.
Thank you. I'll move on. You can maybe pick this up, but I'd move on to Sojan Joseph, because we have 8 people wanting to ask questions with half an hour tops. Sojan Joseph.
Alex, thanks for the written statement. And with your experience in capacity assessment, we heard from the previous panel, especially from the practicing Dr. Clark, how complex it is, and she was explaining how she don't think everyone has enough training in capacity assessment, and it's so complex in the NHS healthcare areas. So your observation about a multidisciplinary involvement in rather than 2 doctors, Do you think that can strengthen this bill if we have more than 2 people involved in that decision making?
Well, I think for many reasons it can, because this is, on the pure capacity side, this is at one level an existential question. This is not a healthcare decision, it's an existential decision. And so the more insights we've got from the more people able to bring their different perspectives, the social work perspective on the person's social circumstances, the medical perspective on the medical condition. So we've got as many eyes on the person as possible and insights into the person as possible. So it's trying to make sure that the decision goes back to, are we really satisfied that the criteria set out at the beginning of the bill are met? So I personally think having MDT, so multidisciplinary, for instance, as you would have in the Mental Health Act detention, we have more than one pairs of eyes on from more than one discipline.
Thank you.
Thank you. Sir Nicholas, I'm going to paraphrase a little bit, but you did say people with Parkinson's will never get a terminal diagnosis, so this bill is no use to anybody, or so no use to us at all. I think you used actually quite a lot stronger language than that when you made your original statement.
Well, I was sort of taken by surprise when she asked me the question in the pub, and I wouldn't have phrased it like that in Court 50.
No, sure. Let's phrase it in a different way then, shall we, today? But would you be able to expand a little bit on your thinking there?
Yes, Parkinson's is such a complex condition. I mean, there are so many. The medically qualified amongst you all know this. There are so many ways, so many symptoms, and the rate of development, the direction of travel. It is an enormously complex condition to know, and that is why it is commonly accepted that you do not die from Parkinson's, you die with Parkinson's, and it's impossible to give a mortality rate as to when it's likely to happen. It's almost impossible. Mind you, when I was doing my research, I was slightly surprised to see that last year 6,000 death certificates had Parkinson's written on them. But they do say that the experts in Parkinson's are the people with Parkinson's, but the people you talk to are quite clear that it is impossible to predict. It's a really complex thing. And so that is why this arbitrary, and I use the word technically, arbitrary 6-month period is never going to be, if a doctor opines conscientiously and honestly, it will never, unless the Parkinson's patient has already developed pneumonia or sepsis or something of that nature, which is other common, or complications from falls, the common reasons for death, you're never going to get that 6-month ticket. That's the thing, that's the problem.
Thank you, Chair. And so, in your view, I think you kind of said it before, and I hate to put words in your mouth, but are you saying that Parkinson's sufferers and other similar
neurodegenerative,
are kind of left out of this debate?
Yeah.
And in view of yourself and indeed the rest of the panel, is there a way to legislate?
Well, I've been, if I might answer that, it's been suggested I want to expand the definition of terminal illness. I don't want to expand it. I want to redefine it so that it is more appropriately focused, in my opinion, on what this bill should be about, which is the relief of suffering. That is what I believe this bill should be about. And you should get the permission to have an assisted death if you are suffering intolerably within 5 months of death or 7 months of death. And there shouldn't be this arbitrary line. Moreover, it shouldn't be open to people who aren't suffering but who happen to have a 6-month life expectancy. There are probably quite a few of them, for one reason or another. Their life expectancy is short, but their pain is being well managed. I don't believe that the assisted dying should necessarily be available for them. I do believe very strongly, and this is not an expansion, but in my view a more appropriate, focused redefinition of terminal illness, that it should be, as in Spain, as in Holland, focused on suffering.
Paul.
Thank you very much, Chair. My questions are to Alex Keane. Thank you so much for your written evidence, which I read with great interest. I've just got 2 points, 2 questions for you, and it follows on nicely from the discussion we've just had now. So the terminal illness definition, is there any risk that if that were to remain in the bill, that this could be challenged under the ECHR? And then my second question, which is completely different, just to mix it up, is you made a really interesting point in your written evidence about we need to give consideration to the National Suicide Prevention Strategy. And I find this really interesting because potentially this bill turns on its head the way we view suicide, and obviously we've been sending a certain message out there, particularly to our young people. Could you elaborate as well on the point you were making in your written evidence for the committee?
Gosh, yes. So there is absolutely no way you can stop people trying to challenge whatever bill, whatever act is passed. There's no way you can stop people seeking to challenge that under the ECHR. We then get into this enormous argument about, is it inevitably discriminatory? And courts today have been very clear, we're not going to get into this. It's for Parliament to decide whether or not to make assisted dying legal. Once it's made legal for some people, but not for others, there is a difference in treatment. Whether it is discriminatory and therefore contrary to Article 14 and 8 and 14 of the ECHR depends on whether that difference is justified. And so what I was trying to be very careful in my language, because I try to be careful in my language, what I think the Bill Committee needs to do and Parliament needs to do is be very, very clear why, if you are going to limit this, because if Parliament does limit it to a cohort of people, and I feel acutely conscious, I'm sitting next to somebody who would be excluded, why it could be explained to somebody that you are not eligible and that is a difference in treatment, but it's perfectly justified. If you can't do that, that will be discrimination. And the courts have been very clear, if you're going to have a system, for instance, it benefits, social security benefits, you don't have to have one, but if you're going to have one, you have to have one which is non-discriminatory. So that's the answer I can give to that. And the one thing I can say is you can't stop lawyers trying to challenge. And that's what they will do.
All laws discriminate. All laws discriminate. 69 miles an hour is not an offence, 71 is. I mean, all laws discriminate. The question is whether it's justifiable.
And it's also a question of providing legal certainty, which is why the definitions in the bill are so important. But provided that is articulated clearly, and it's within what the European Court so often calls the margin of appreciation, which it gives to sovereign states, and although I agree with Alex that a challenge may be possible, I cannot see a successful challenge to the bill if drawn in the sorts of provisions we have here. And indeed, we haven't seen local nation-state examples of this sort being struck down by the European Court elsewhere in Europe. So I think it's very unlikely that we'd see such a strike down here.
I really hate to get into with such eminent lawyers. There hasn't been a case in Strasbourg seeking to say that a limited class of case is discriminatory, so we just don't know. And I think to some extent
I agree with that. I've changed my mind twice about this subject. So.
Thank you. Would you mind if I just very, very quickly touch on
the moment?
Of course.
Daniel Francis.
Thank you, Chair. So, Alex, if you could also, in your written evidence in paragraph 8, you touch on clauses 9, 15 and 18 of the bill and the potential complications that could arise when the substance is taken. And I just ask if you could expand on that slightly and the concerns you have on that element.
So my concerns arise here because, and I totally and I should make it absolutely clear, all I'm trying to do is try and make sure that whatever law is passed is a good law and has as few inadvertent consequences as possible. My concern arises out of the fact that, understandably, the proponents of the bill want to make it very, very clear this is about people carrying out the final act. And no doctor is allowed to do something which involves going beyond that. But at the same time, we have a situation where doctors, and I'm using the word doctor slightly loosely, but that's, for present purposes, that's what we're talking about. The doctor has to be present and has to remain with the person. And we know that there will be some people for whom there are complications. And my concern is to make sure that there has been sufficient consideration given as to what exactly a doctor is meant to do at that point. Because it seems to me that that ends up putting the person who is undergoing those complications in a horrible position. It is also, and I'm perfectly happy to use this phrase, putting the doctor in a position of extraordinary moral distress. Are they then at that point supposed to try and rely on the doctrine of double effect and say, all I'm trying to do is treat the complication, I'm not trying to bring about your death, but the bill is saying, no, you're not allowed to do that. And so it seems to me that I understand entirely why the intention is to say doctor must always be, as it were, hands off. But you need to be super clear. You're going to put some people in some very, very, very difficult positions, and Parliament needs to be very, very clear-eyed about that.
Thank you, Chair. Can I just want to stick with Clause 18, if I may, because as it currently stands, there can be some assistance by the clinician, but there can't be total delivery or administration by the clinician. So you could end up with a scenario whereby, for instance, you have somebody who's tetraplegic, who then gets a terminal diagnosis, they have capacity to make the decision, they want to end their life, but they don't have the physical means of doing so. Do you think that's open for challenge? And I'll start with Sir Max on this, on grounds of discrimination.
I wouldn't look at it on grounds of discrimination. What I would do is put that clause alongside what are generally referred to as the slippery slope arguments in other jurisdictions. And in other jurisdictions, Canada might be one, some of the US states might be another. The provision of life-ending medication is expressed in a form of treatment by a doctor. This is not that. So we're clear, I think, when we're reading Clause 18, that this is not a permission to administer. In fact, it's a prohibition on administration. It is making available in certain tightly defined circumstances and then standing by, not necessarily in the same room, subparagraph 10 of paragraph or clause 18, whilst the self-administered medication takes effect. Having said that, I am absolutely clear that there is so far that a bill or an act of Parliament can go as primary legislation, and there is then further distance that must be covered by the provision of practical and professional rules here under the auspices of the National Health Service to indicate precisely the circumstances physically in which this will happen. I don't see that as discriminatory. We're dealing with a tight category of defined individuals to whom this does apply, and it doesn't apply to anybody outside that. We've just discussed that. But it is not prone to the slippery slope arguments of something that is generally to be made available in the course of treatment. In fact, the bill's been couched in a very different way.
And can I just bring Sir Nicholas in on that, because you refer to it directly in your proposed amendments?
I do. I mean, what particular aspect do you want me to address? You've ranged quite wide. I mean, in relation to the administration of the substance, it's interesting in Spain, which is now in its second full year of doing this, that take-up has been extremely low. Only 700 requests, quarter denied, quarter of the people died prematurely, 300 were granted. But of the 300 granted, 95% of them were administered by the doctor, and only 5% were auto-administered. So I'm trying to work out culturally in Spain why maybe people go when they're extremely infirm, and that's the reason for it. But I'm not able to see the moral distinction between between having it administered and doing an auto-administration. And your question that you asked, I mean, I think there are devices which enable somebody who's locked in to end their lives by a blink of the eyelash, yeah. But aren't there? Yeah.
I'm grateful. Thank you. Thank you. We've heard from two witnesses now, Sir Nicholas from you and from Dr. Ahmedzai from the earlier panel, around this question, particularly around the judicial oversight. So I just want to, while we've got Sir Max here and Mr. Rockeen, about your observations around the proposals from those two witnesses that an alternative to a High Court judge overseeing that process would be some form of panel or tribunal, potentially multidisciplinary. Can I just ask, while we go through you here, about your view on that and the legal implications for that?
I think I'd say two things. Firstly, it bears weight that looking at all the provisions in this bill, the additional level of scrutiny that is currently being called judicial scrutiny or approval is absent in all the comparative examples around the world. So that makes this already a tighter pre-legislative model than we see in other countries that have gone down this route, and that's worth remembering. But secondly, whilst I'm not a family lawyer, at least I was, but a very long time ago, whilst I do think that the family division of the High Court would be very well placed to perform the sort of exercise that's enshrined in current drafting, which is not a rubber stamping exercise but is a substantive consideration of heavily objective medical opinion arrived at by not one but two doctors, one of whom is not the treating doctor. I, of course, listen to and accept the question of pressure on the justice system generally. And that is something which this committee will be concerned about, because we want something, if passed, that is workable. So I heed what James Mumby said. The sitting judiciary, for good constitutional reasons, are highly unlikely to say anything. But I do think, therefore, that there is merit in looking at Clause 12 and performing actually quite a simple exercise under the heading court approval, which for me would be to go through subclauses 1 to 6 inclusive of Clause 12, and on each occasion where at the moment it says High Court, replace it with something else. Personally, I have an aversion to the word tribunal, which indicates a sort of right and wrong, some kind of fault-based system. That's not what we're talking about here, but a panel, as Nick said,
appointed by the official solicitor.
Is the way to go. Whether appointed by the official solicitor or not, dare I say it, because I'm sitting next to a very distinguished one, I do wonder about the recently retired judiciary and the role that they could play under a replacement panel system.
No, that's what I had in mind, the official solicitor looking at the retired judges.
Yes. Yeah, so there is capacity there in terms of legal professional capacity amongst the retired judges. Not that they would sit alone on a panel. It would bring with it the extra benefit of having suitably qualified medical professionals like the Spanish model. So yes, I do think that could be done. That's not the same thing as saying the High Court approval model is fatally flawed and couldn't be introduced. But I do think there's a viable alternative which is worth looking at.
My only observation, and I said it in my written evidence, but I do just want to say this out loud. I do think you have to think very carefully about what purpose any form of this oversight is actually serving societally if the oversight panel, whether that be a judge, whether that be a panel, can't decline to approve an application if they consider that the reason the individual is seeking assistance in dying is because of service provision failures by statutory bodies responsible for meeting their health and social care needs. That is a question of principle, and I just want to make sure that is squarely before you.
Thank you. Liz Savile-Wallace.
A question to Alex Keane, please. And I noticed your comments in your evidence about presumption of capacity, concerns over that, and I know that you've written in the past as well of concerns of different disciplines in relation to different disciplines having different definitions of capacity. You also say later on in your evidence that multidisciplinary consideration of the circumstances in assessing eligibility could be what I would like raised is how that having that multidisciplinary eligibility assessment might alleviate some of your concerns in relation to capacity decisions.
Well, I think it's partly because it's making clear, I mean, that we've got capacity, but we've also got to make sure it's settled, we've also got to make sure it's informed, we've got to also make sure it's voluntary, and we don't have things like pressure or influence going on. So I think it's important to make clear, I'm not just saying this is about all the weight going on capacity. But, for instance, if you've got social workers involved, you've got palliative care social workers, say, involved, assuming this is a palliative care situation, they are going to be far better informed about what options might be out there than a doctor, potentially, depending on the doctor. Social workers, more generally, might well have expertise in picking up signs of coercion or signs of influence than a doctor. But I really don't want to necessarily get into some disciplines are good at X, some disciplines are good at Y. I've come across brilliant examples and bad examples in both zones. So it's partly the multidisciplinariness and the very fact if you've actually got more than one person trying to talk it through, because in every single, I always try and tell people when I train, 85% of capacity assessments aren't all that difficult. They're just made difficult because you don't have time or you're not listening. But it's the 15% are more difficult. And I think a lot of these will be into the 15% zone. And into the 15% zone, the more people you can have thinking about it, so long as they've got an agreed framework within which to think, the more reliable, the more transparent, the more accountable the outcome's going to be.
Thank you, Chair. Just wanted to pick up on your evidence, Sir Nicholas, in relation to the panel that we've just been discussing again with Sir Max. 3 questions, I suppose. Firstly,
what do you envisage under your model that the panel is doing? Is it ensuring that a lawful process has been followed, or is it doing something more than that?
Former.
The former, that's helpful. What information, secondly then, do you think the panel needs in order to reach a determination on that
Well,
question?
it's going to have the statements in Schedule 1, 2, 3 and 4 signed by both doctors twice. And then the panel, this is where it gets slightly tricky, because is the panel expected to be a ferret? And to ask, this doesn't quite chime for me. And I think this is something that the committee is going to have to consider, is that how investigative the panel is, or is it going to be purely just sit back and accept passive and just work on the material it's got, or should it does have to, of course, under section clause 12, it does have to hear orally, doesn't it?
That's right.
And so that might get the alarm bells going. But I believe that the panel should be entitled to call for further evidence if it's got concerns.
And
I mean, as I say, I've been trying to find out why 10% of them were rejected by the panel in Spain. There must have been some kind of procurement of further evidence by the panel in order to do that.
Yeah, and I suppose my third question then is, how would you envisage such a panel, if at all, interacting with the High Court, say a final right of appeal to the High Court, similar to what you've got in the bill?
Article 10 of the Spanish law gives an appeal on a point of law to their High Court. So I would have the same, an appeal on a point of law to the High Court, only on a point of law.
Either way, it would have to be either way. It couldn't just be against a decision not to approve. I think that logically, because it'd be very. I mean, the current model is very odd, saying you can only appeal one way from the High Court.
Yes, I mean, Spain gives either side the right to appeal, so I agree with that. But it's confined to a point of law.
And Chair, can I see if Sir Max wants to come in on any of that?
Yes, I would only add, and I wonder whether that is the only route through, namely leaving open a judicial review appellate process, or whether, for example, as we imagine with a number of commissioner-led processes already in this jurisdiction, the panel, or actually, frankly, I suspect panels, plural, who might sit regionally, chaired perhaps by the retired judiciary, would have an appellate route to a national body, you could call it a national commission, instead of a judicial review route to the court. So there are a large number of commissioners, some sitting under the Home Office, some sitting under the Ministry of Justice. In a sense, I was a commissioner when I was the independent reviewer of terrorism legislation with closely defined powers. There are many others who sit in an enhanced regulatory position, highly qualified individuals who you could describe as a national commissioner, if that's an appropriate word, who would have superintendence over regional panels, the power to appoint retired judiciary, perhaps with the assistance of the official solicitor, to sit on those regional panels, and then to have an internal appellate mechanism.
I mean, you have to have an appeal process of some type, because otherwise there'll be judicial review.
Yes, I
if there's no appeal, there's judicial review. So you have to have an appeal of some type, or there will be judicial review.
Thank you.
If we want to ask some more questions, we've got about 6 minutes or so. Jake Richards, you did have a possible question.
Some of it's been asked
earlier on.
That point, just exploring this appeal. If it was, as Alex
pointed, either side could appeal. Who would be appealing against a decision to allow assisted dying?
Oh, I mean, the relations who say my father has been pressured by his new wife to do this, and a child's objecting, father's given permission, and the child who's asked to intervene is joined. There would have been some process where the child would have been allowed to become a party to the proceedings, because that will have to be specified in rules, and then that would be that person would be the appellant.
Just the bill at the moment doesn't provide for, and for good reason, but potentially doesn't provide for family members receiving notice of this.
Well, it does.
It's an autonomous decision. So
no, but it says procedure. They can determine its own procedure.
Yes. No. Sorry. I meant that in terms of. Sorry, Chair.
I really am giving you an opportunity to ask a question. So ask the question, and we'll get the answer back, and then we're going to move on. I don't want this dialogue, I'm afraid.
Forgive me. Sorry, Chair. I meant in terms of the assisted dying process, there is no automated mechanism for family members, or indeed any third parties apart from the doctors in the bill to have notice of this intention. Is there a concern with regards to this appeal point that perhaps interested parties would not know?
I'd suggest the key to this is in clause 12.5, and that's why I've recommended just striking out the words High Court and putting in the word panel, and then reading the whole of clause 12 as amended, with those situations in which there are steps which must be taken, and there are many, and those in which there are steps which may be taken. And in 12.5 here, following the logic, we'd imagine that a panel, just as the High Court, may hear from and question in person the person who made the application, but must hear from a coordinating doctor. Now, the appellate mechanism, which I agree there needs to be, will be looking sharply at the operation of that subsection. In other words, when the panel made its decision to refuse, on what basis did it make that decision, and from whom had it heard? We can well imagine situations in which a coordinating doctor, having taken his or her own steps to ascertain the views of the nearest and dearest, would satisfy the panel as to what the views of the family are. The reverse of that is there's no indication here, this has gone all the way through the panel process, no indication that the family have been made aware or considered at all. I would think that's going to be a rare scenario, but I'm not a medical professional. But I think you can cover that, perhaps with some changes here or there on what you impose on the panel as a mandatory duty and what you leave by way of discretion, subject to the rules of procedure that the panel would then adopt.
Thank you. This is for Sir Max Hill and Alex Rook. Your insight on Clause 12 has been really helpful. What procedures would you recommend being adopted for testing and, if need be, challenging the evidence as part of an evidentiary process linked to the panel you've set out?
Thank you. This is for the moment predicated on the fact we're still in the High Court, as opposed to slightly making up policy on the fly about a panel. Assume it's the High Court for a second. It seems to me the High Court has got to be discharging a properly inquisitorial jurisdiction, which means it has to be armed with the tools to do that, which includes arming it with the tools to call for its own evidence. And it also seems to me that the High Court being armed with its own ability to not just receive evidence from one side and have someone testing it, which then brings you to the only player in town who could possibly do that would be the official solicitor as advocate to the court. And I don't want to emphasise too much the question of resources, because if Parliament thinks this is sufficiently important, the resources will be voted through. But it is vitally important to note the official solicitor is completely overloaded. And asking the official solicitor to act as advocate to court in every single one of these cases, and you couldn't have it optional. You can't say, well, it's some and not others. If it's going to be inquisitorial, the High Court's got to have the ability to say, this is one-sided, someone needs to tease it out. So the official solicitor would have to be funded to be advocate to the court and, if necessary, instruct lawyers in every single case.
Max. The model that I was espousing would not necessarily involve the official solicitor at all. It would make no draw on the administration of the court or any officer of the court, still less full-time judges. It would allow the appointment of recently retired judges, as we have in a number of scenarios, surveillance commissioners, for example, and a fresh administration. With that, as with the High Court model at the moment, there's the primary set of provisions which Parliament must impose, and it's important that that provides sufficient for what Alex called an inquisitorial function. In part mandatory, those things that the panel must be satisfied about, and they're set out in subclause 12.3, and then those that are discretionary set out in subclause 12.5. But what sits between the two is very important here, currently expressed as rules of court, but it would be rules of the panel or the commission that appoints the panels. In a court scenario, we're all familiar with criminal procedure rules, civil procedure rules. That's the secondary stage that is reached once the primary legislation's been fixed. That too would apply on the commission or panel process. But as I say, I don't think necessarily it would involve using existing paid judicial resources at all.
That's extremely helpful, thank you.
Thank you very much for that. Unless there are any more pressing questions, I think we have 1.5 minutes in. It literally will be a 10-second question and a 20-second answer. Unless you can do that, I'm going to call it to a close.
Go for it. Great sympathy with your position. However, how would you frame this law so it will cover yourself?
I would frame the law to define terminal illness in the way that it's defined here in its first part, but in its second part, I would substitute where the person's death in consequence of that is. I would delete subclause B and substitute suffering intolerably.
Thank you. Order. That brings us to the end of the time allotted for the committee to ask questions, and I thank our witnesses. On behalf of the committee and for your forbearance. Point of order.
Thank you.
Sarah Olney.
Up at the very beginning, I was really keen to ask a question in this session because it's pertinent to an amendment I myself have laid. How could you advise me to make sure that I've got the opportunity to ask my question?
Well, I'm more than happy to speak to you afterwards, but I've got to say, we had lots of questions today. I was trying to get people in as much as possible, and there has to be an element of self-discipline from people asking the questions as well and interrupting. So I'm more than happy to facilitate if I possibly can, but I'm afraid there's a responsibility on members also to look to other members' needs. Thank you very much for your evidence. Thank you very much.
Suicide prevention was asked or answered. Can I just get it in writing? Is there a formal way to do that? I'm very happy to do it in writing.
That's what it's right to the witness and ask it. Well, there might be signal. I thought it's now just read one so we can give you a
Yeah, but can you do it?
There might be.
Obviously, it's just they got excited by ECHR and distracted them.
Well, they you got the witnesses in? Yes. Oh, sorry. Do you want to bring the witnesses forward? Who's bringing them up forward? Oh, sorry. Okay. Sorry. Order. We will now hear oral evidence from Dr. Ryan Spiegvogel, who is Senior Medical Director for Aid in Dying Services for Sutter Health, California, and Dr. Jessica Khan, who is Medical Director for End of Life Washington, both will be via Zoom. I call members to ask questions, but in view of the last point of order, can I be absolutely clear? I will ask members, and I will interrupt if necessary if questions are too long to the witnesses. We don't have much time. People do want to get their questions in, and there has to be that element of self-discipline in that regard. Kim Leadbetter.
Thank you, Chair, and I will try and be brief. Thank you for joining us from wherever you are in the world. It's great to have you with us today. I'll get straight to the point. There's understandably a significant amount of nervousness about the potential change that this bill would create within England and Wales. Could you talk to us a little bit about what the process has been like in your jurisdictions and what it looks like now, your experience, but also maybe particularly focusing on questions around mental capacity and around coercion? Dr. Spiegvogel, maybe first.
Yes.
You're on mute.
I'm afraid.
He's unmuted, but we can't hear him.
Just bear with me, I'll mute. Can you just check?
Can you hear me now?
Yes.
Thank you. Go ahead. Thank you.
After several years, you'd think I'd get this right. Hi, members of the committee. Thank you all for having me today. So yes, I'm Ryan Spiegvogel. I'm Senior Medical Director for Assisted Dying Services for Sutter Health in California. I have been an assisted dying physician for the past 8.5 years since the law went into effect here. And so I've seen many terminally ill people going through the process. And you asked specifically about coercion and capacity, is that correct? So capacity, determining mental capacity is something that we as physicians do every day. There are codified steps and processes for us to be able to assess a person's capacity. Capacity for anything, any procedure, medical intervention, anything is presumed that the patient has capacity until they are deemed to not have capacity. And we do that through asking questions, determining their understanding of their disease process, asking them to repeat what their understanding of their options are, making a decision, and then telling us their judgment as to why they were coming to that decision. So that's something that we do every day. It's oftentimes informal. If I'm, for instance, prescribing someone a blood pressure medication, I might not go through the entire process of assessing capacity, but in longer or in higher stakes kinds of conversations, like end of life discussions, I usually do ask somebody to repeat back to me what it is they understand of their disease process and their options, what their decisions are, and why they are making those decisions. And that's basically exactly what I do in these conversations. In terms of coercion, I understand the concern. It is a very valid concern that people have. I have seen this now in many jurisdictions in the US where different states are considering legalizing assisted dying. But I'll tell you, in practice, it just doesn't happen. So I've seen assisted dying laws go into practice across numerous states, and I have helped many, many people through this process, and I have never seen a case of even where I suspected coercion. People are just not that good of actors. So we get the family out of the room, we dig deep into their concerns and their justifications and the reasoning behind their choices. And it is often extremely crystal clear when you are speaking to someone who is suffering from some terminal illness. They are very focused on their symptoms, they are very focused on their quality of life, they are very focused on their suffering. I don't ever get the sense from them that their family or their doctors or anybody is coercing them into the decision. In fact, if anything, I've seen it many times the other way around. I tend to see where the patient is really ready to let go and the family is really not ready to let go, and the family puts up varying degrees of roadblocks to the patient accessing assisted dying. So I've seen many cases of people being coerced out of it. I've never seen someone being coerced into.
That's incredibly helpful. Thank you.
I'll stop there.
Thank you. Dr. Khan, do you want to add anything to that and maybe touch on the training that takes place around identifying these things and those conversations that take place?
Yes, I would echo exactly what Dr. Spielberger has said here. We are trained as part of our medical training to assess capacity, both in small ways and in big ones, depending on the size of the decision at hand, which, as he said, throughout our medical training, this is something we are trained to do and to continually assess at, progressively with a patient over time as we're seeing them in subsequent visits as well. And so this is really not different from that, although obviously the stakes are a bit higher than, as you said, a blood pressure medication discussion. But really looking at, are they able to voice a reason for making their decision? Do they have a logic behind it? Do they have a set of values that they can express? Is their decision consistent over time? We're looking at, a longitudinal assessment rather than just one fixed moment in time. And, over the course of our assessments, it really does become clear in almost all cases that somebody either does or does not have the capacity to make this decision or any decision. And so this is really not outside the realm of what physicians are trained to do in any other case of medical decisions, especially large ones. And in the case of coercion, I agree that Virtually all of the time, I would say that it's the opposite way, where people and family members, loved ones, well-intentionedly are trying to coerce or convince someone not to make this choice or not to proceed with this option. They may have it available, rather than them pushing them to actually do it. But I think the way to properly assess that is to ask open-ended questions, to, as Dr. Spielvogel has said, like have them in the room alone, at least for a portion of the assessment, so you can have a one-on-one conversation, ask the questions in various ways, and so you're seeing the consistency of answers over time, as well as looking for non-verbal cues that may indicate, that something else is going on. And so I have also never come across a case where I felt that a patient was being coerced into this decision by a family member, but rather the opposite.
Thank you.
Thank you. My question is just about how it's going, how you've implemented it, and what changes you've made from the start when it began to now. What sort of teething problems you found as you were going along, and what adjustments you made to your process. So Dr. Spielvogel first.
Thank you. So the original version of what's called the End of Life Option Act, which was the bill that legalized assisted dying in California, when that went into effect in 2016, it then was amended in 2021, I believe. And those amendments, the main one that did was it shortened the waiting period. So there was a 14-day waiting period, mandatory waiting period, between two verbal requests that a patient would give directly to their physician. And what we found when we were studying it was that approximately 30% of people died during the waiting period. And after many conversations with patients where the waiting period and the thought process behind it is that somebody is making a persistent and well thought out, non-capricious decision when they're asking for this. But there is a false premise in there.
Sorry, Doctor, we have a vote in the chamber, so we will have to suspend the sitting for 15 minutes. So we'll be back in 15 minutes' time at 16:40. And please bear with us while we carry out the vote. Thank you.